Every day in the USA, people find themselves in court.
Yes, I am.
Every day in the USA, people find themselves in court.
Yes, I am.
All right. Okay. Oops, sorry. Let's go on the record in the matter of the city of Riverview versus Vincent Wolford, 25347.
Ready? Okay, sir. Your Honor, good morning. Richard T. Serrano, P. 33828, appearing on behalf of with my client, appears to be my right. I appear today as MIDC counsel, Your Honor, for the purpose of arraignment pretrial. Sir, please state your name.
Vincent Wolford.
All right, good morning, sir.
Good morning.
And thank you for dressing appropriately for court. And so counsel, today is the date scheduled for the arraignment pretrial, as you stated, and as to the arraignment.
Your Honor, I've explained to my client the nature of the proceedings against him, all the maximum penalties and that are possible on this charge. He understands them. And today he's been advised of advice and rights, but he's also signed a form for that. And thereby we waive formal reading today, ask for a plea of not guilty to be entered on his behalf.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial counsel.
Your Honor, as to pretrial, I'd like to speak to my client, he wishes to plead guilty as charged. And Your Honor, we're hoping that the court will consider an HYTA, homes of trainee status for my client. I've explained to him what that entails, and he's ready for the court's examination.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right.
Yes, Your Honor.
And you heard the plea that was stated on the record, correct?
Yes, Your Honor.
And as to the charge of contributing to the delinquency of a minor, how do you plead?
Guilty.
You've gone over your advice and rights with your attorney, correct?
Yes, yes,
And you
Your Honor.
understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
And you also understand what the HIDA status is, correct?
Yes, yes,
That's
Your
what I
Honor.
explained to you.
Yeah.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel, if you can please pardon your client.
Mr. Wolford, on March 13, 2025, approximately 10:30 a.m., were you in the area of Breland Park in the city of Riverview?
Yes.
You were in a vehicle, correct?
Yes.
Around that time, you had been contacted prior to that by someone that wanted to purchase a vape from you. Is that correct?
Yes, Your Honor. Yes. Yes.
And then at some time, a young lady showed up, turned out to be a minor, age 16, and you sold her a vape from your vehicle. Is that correct?
Yes.
And that was the end of that, right? You collected the money?
Yeah.
I'm satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea as charged, and there will be a sentencing date scheduled. There will be a sentencing date scheduled. You'll receive that date from probation, and the court will determine your eligibility under HIDA status. And counsel as to bond.
Your Honor, there's one thing I forgot to complete. At that date and time, sir, March 13, 25, what was your age?
At that time,
Yes, how old were you then?
29, 19.
Thank you.
I'm sorry?
19 years old.
Thank you. I'm sorry, Your Honor, what was the question?
As to bond.
Oh, Your Honor, my client's not on probation or parole. He's working full-time as a union in a cleaning agency. And he lives president of his father, single, supports no minor children, has never failed to appear in court before. And Your Honor, I'm sure he will come next time in court because he's most concerned about this matter. Something that won't ever happen again, what he's told me.
All right, so, sir, you also are not allowed to have possession of a vape.
No.
Because
not
you
at
yourself
all.
are considered a minor for purposes of vape.
Yeah. Yes, Your Honor.
So, and then not only are you using it for yourself illegally, but then you're selling it illegally to even more minors,
It was just one, Your Honor. Just one person.
right? That was one too many.
One is too
Yeah,
much.
you're 100% right, Your Honor.
So, all right, if you were to test right now, what's in your system?
Marijuana, and that's it.
Okay, do you have a valid prescription for marijuana?
No, I just
Okay.
use it for my back.
Well, sir, if you feel as though you need it for your back, then get a prescription,
Yeah.
a valid prescription from your treating physician. Not just from any, willy-nilly medical staff that you happen to see and tell them that you have back pain. Why do you have back pain?
Because when I think it was around 12 or 11 years old, I fell like 12, 15 feet off of a playground set on my back, and ever since then, my lower back's been all messed up.
Okay, and so, what do you do to alleviate that pain, other than marijuana, which is illegal for you right now?
I get massages because my mother used to be a massage therapist, and then we also put like stuff, like lotion and stuff that helps with that on my back, but other than that, that's pretty much it.
Okay, well, sir, I would suggest, that you, work on something, on alleviating, is it all the time, or some of the time, or?
No, actually, it was only some of the time, and with my job right now, I actually can't smoke, so I was trying to stop and, get off of it fully. And I told them, I let them know beforehand that I did use it as well, but I've been doing good for so far, I believe.
Okay, and so how long have you been at this job?
Probably like a month and then, almost a month and a half.
Okay, so when's the last time you used marijuana?
Like, probably a few days after I got the job.
Okay, so not anything recent?
No.
Okay. So, sir, I'm going to, are you currently on probation or parole anywhere?
No, Your Honor.
All right, the court's going to order a $5,000 personal bond. You're not to possess or consume the alcohol or drugs that are not prescribed. You're also not to possess any vaping, okay?
Yes, Your
Any
Honor.
vaping product or anything. All right, and then you will receive your condition of bond, you'll receive your pre-sentence interview information, your pre-sentence interview date, and your sentencing date, okay, confirmation.
Yes, sir.
All right, thank you, have a good day. Terry, well, let's go off the record for a moment. Because I'm just, okay, oops, sorry. Let's go on the record in the matter of the city of Riverview versus Vincent Wolford, 25347.
Ready? Okay, sir. Your Honor, good morning. Richard T. Serrano, P. 33828, appearing on behalf of with my client appears to be my right. I appear today as MIDC counsel, Your Honor, for the purpose of arraignment pretrial. Sir, please state your name.
Vincent Wolford.
All right, good morning, sir,
Good morning.
and thank you for addressing appropriately for court. And so counsel, today is the date scheduled for the arraignment pretrial, as you stated, and as to the arraignment.
Your Honor, I've explained to my client the nature of the proceedings against him, all the maximum penalties and that are possible on this charge. He understands them. And today, he's been advised of advice and rights, but he's also signed a form for that. And thereby, we waive formal reading today, as per a plea of not guilty to be entered on his behalf.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial counsel.
Your Honor, as to pretrial, I'd like to speak to my client. He wishes to plead guilty as charged. And Your Honor, we're hoping that the court will consider in HYTA, homes with trainee status for my client. I've explained to him what that entails, and he's ready for the court's examination.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right.
Yes, Your Honor.
And you heard the plea that was stated on the record, correct?
Yes, Your Honor.
And as to the charge of contributing to the delinquency of a minor, how do you plead?
Guilty.
You've gone over your rights with your attorney, correct?
Yes,
And
yes,
you
Your Honor.
understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
And you also understand what the HIDA status is, correct?
Yes, yes,
That's
Your
what I
Honor.
explained to you.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No,
Any immigration issues?
no.
And counsel, if you can please pardon your client.
Mr. Wolford, on March 13, 2025, approximately 10:30 a.m., were you in the area of Greenland Park in the city of Riverview?
Yes,
You were in a vehicle, correct?
yes,
And around that time, you had been contacted prior to that by someone that wanted to purchase a vape from you. Is that correct?
yes, Your Honor. Yes, yes,
And then at some time, a young lady showed up, turned out to be a minor, age 16, and you sold her a vape from your vehicle. Is that correct?
yes,
And that was the end of that, right? You collected the money?
yeah.
I'm satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea as charged, and there will be a sentencing date scheduled. There will be a sentencing date scheduled. You'll receive that date from probation, and the court will determine your eligibility under HIDA status. And counsel as to bond.
Your Honor, there's one thing I forgot to complete. At that date and time, sir, March 13, 25, what was your age?
At that time,
Yes, how old were you then?
29, 19.
Thank you.
I'm sorry?
19 years old.
Thank you. I'm sorry, Your Honor, what was the question?
As to bond.
Oh, Your Honor, my client's not on probation or parole. He's working full-time as a union in a cleaning agency. And he lives president with his father, single, supports no minor children, has never failed to appear in court before. And Your Honor, I'm sure he will come next time in court because he's most concerned about this matter. Something that won't ever happen again, what he's told me.
so, sir, you also are not allowed to have possession of a vape.
No,
Because
not
you
at
yourself
all.
are considered a minor for purposes of vape.
Yeah. Sure.
So, and then not only are you using it yourself illegally, but then you're selling it illegally to even more minors,
It was just one, just one person.
right? That was one too many.
One is too
Yeah,
much.
you're 100% right, Your Honor.
So, all right, if you were to test right now, what's in your system?
Marijuana, and that's it.
Okay, do you have a valid prescription for marijuana?
No, I just
Okay.
use it for my back.
Well, sir, if you feel as though you need it for your back, then get a prescription,
Yeah.
a valid prescription from your treating physician. Not just from any, willy-nilly medical staff that you happen to see and tell them that you have back pain. Why do you have back pain?
Because when I think it was around 12 or 11 years old, I fell like 12, 15 feet off of a playground set on my back, and ever since then, my lower back's been all messed up.
Okay, and so, what do you do to alleviate that pain, other than marijuana, which is illegal for you right now?
I get massages because my mother used to be a massage therapist, and then we also put like stuff, like lotion and stuff that helps with that on my back, but other than that, that's pretty much it.
Okay, well, sir, I would suggest, that you, work on something, on alleviating, is it all the time or some of the time, or?
No, actually, it was only some of the time, and with my job right now, I actually can't smoke, so I was trying to stop and, get off of it fully. And I told them, I let them know beforehand that I did use it as well, but I've been doing good for so far, I believe.
Okay, and so how long have you been at this job?
Probably like a month in there, almost a month and a half.
Okay, so when's the last time you used marijuana?
Like, probably a few days after I got the job.
Okay, so not anything recent?
No.
Okay. So, sir, I'm going to, are you currently on probation or parole anywhere?
No, Your Honor.
All right, the court's going to order a $5,000 personal bond. You're not to possess or consume any alcohol or drugs that are not prescribed. You're also not to possess any vaping, okay?
Yes, Your
Any
Honor.
vaping products or anything. All right, and then you will receive your condition of bond. You'll receive your pre-sentence interview information, your pre-sentence interview date, and your sentencing date, okay, confirmation.
Yes, Your Honor.
All right, thank you. Have a good day.
I'll put him in here.
Okay. All right, we're on the record in the matter of the city of Riverview versus Keon Thomas, 25346.
Good morning, Your Honor. Neil LeBlanc here on behalf of Keon Thomas. Sir, state your name, right? Keon Thomas. Thank you.
Okay, hi. Hi, cutie. Sorry, for the record, that's not Mr. Thomas, that's the little girl he's holding. What's your name?
Carmen Thomas.
Aw. Okay, and so today is the date scheduled for the arraignment pretrial in this matter, and counsel as to the arraignment.
Yes, my client waives formal reading and stands to meet to the charge.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, excuse me, as to the pretrial.
As to the pretrial, we're asking for a short adjournment. I think there's just a reinstatement fee that he was unaware of, that he needs to pay to put himself in a better position, and we'll come back and talk with the city attorney after he's able to do that. So I think it's just a misunderstanding. That's the court for the 2-week adjournment.
Okay, and so the court will adjourn this to, you're here on the 28th, so we'll adjourn this to the 28th. Does that work for you, sir?
Yes, ma'am.
Okay. Kelly isn't here, so I'm probably gonna mess up the docket time. I'm just gonna pick 10:15. Okay,
You said 10:15?
yes.
Okay, is there an earlier time?
Oh, we can do earlier.
Yes, as early as possible, please.
Okay, well, we'll do 8:45?
Thank you.
Okay. All right, then ask the bond counsel.
Esteban, again, this is basically a traffic situation. He understands what he needs to do to get this clarified. He came in today with no more prompting than a notice to appear. So I think he's well motivated. He is employed. He's obviously a dad, works at Ford Motor Company. He's well motivated to get this cleared up. And I think there's no fear that he'll come back. A personal bond will be appropriate.
Okay. All right, and so, sir, how'd you get here today?
My brother dropped us off. Her mom was supposed to be picking us up.
Okay, so you didn't drive here?
No.
How do you get back and forth to work?
Typically,
Okay, so you want to get your license back, right?
yes, as soon as possible. I wasn't aware that it was still suspended today. I thought when I paid the ticket, it would at least like void the suspension, even
No,
though
you're right, there's a separate fee with the Secretary of State.
he
So,
let me know. So
Yeah, so did you drive here? Okay, I will say, that's the first I've seen with someone saying no with their head and saying yes, so, okay. So, sir, you gotta make your other arrangements to get home. You cannot drive out of the parking lot,
okay,
okay?
okay,
So, since you told me your child's mother was gonna pick you up, give her a call,
okay.
okay? And then have maybe somebody come with her so they can drive your car, but do not drive out of the parking lot.
Okay.
If you wanna get your license back, don't keep driving without a license, it's going to extend that even further,
Okay,
okay?
appreciate it.
All right, they will be watching, sir, so do not drive out of the parking lot.
Okay.
So if you end up driving out of the parking lot and you get arrested, can't say I didn't tell you. Really? All right, the court's gonna order a $5,000 personal bond, no driving unless you have a valid license. So in the event you, sir, decide that you're not going to heed my advice, or my order, I should say, and you're going to drive out of the parking lot, not only will it be a new charge, it will also be a bond violation. Okay, so do not drive.
Okay.
I can't be any more clear. All right, we'll see you back in 2 weeks.
All right, thank you.
Thank you, have a good day. Amanda over there, Bobby?
Yes.
Okay, very good, all right. And we are on the record in the matter of the city of Wyandotte versus Amanda Trent, 25651A and B.
Good morning, Your Honor. Neil DeBlois here on behalf of Amanda Trent, who joins us via Zoom from the jail. Ms. Trent, could you state your name, please?
Amanda Trent.
Thank you.
All right, thank you. And so, counsel, as to the arraignment, please.
Yes, my client waives formal reading and stands mute to the charges.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And we will schedule this matter for pretrial on May 21st. At 9:45 a.m. Terry, do you have another one of these? This one doesn't work for me. Unless you can get it to work. Thank you. Okay, and then counsel as to bond.
As to bond, I was unable to get much information out of Ms. Trent this morning about her background. She was reluctant to share much with me. The address on Norman Street is not her correct address. She gave me another address on Steinhauer in Westland. She did indicate to me that she has a couple of children that she is, who are under her care, but she does not have a job. That's about as much information as I could get with respect to that, other than what's before the court today. We asked for, take that into consideration, set a nominal bond.
Okay, so Ms. Trent, you reside on Steinhauer Street,
Yes. Yeah.
and how long have you lived there?
I've been there like 4 years.
On
At
Steinhauer,
least 4 years.
okay, and that's on Steinhauer Street?
Yeah, in Westland.
Okay, and then I'm not sure why you filled out a request rights form today that indicated you lived on First Street in Wayne.
And I have 2 addresses, but I stay at that address. I told them that. That's why I gave you the address that I stay at, so I can get the paperwork.
I'm sorry, you say, you live Steinhauer.
Yes, I live at the one in Steinhauer,
at.
but I also own the one in Wayne, so that's why I try to tell them. I have 2 houses.
Okay, ma'am, who resides in the home on First Street?
Me, they're both my houses. They're in my name. I gave them both my addresses.
Ma'am, if you reside on Steinhauer, who lives at the First Street address?
Me, I stay at both houses. That's what I'm trying to say. I own both houses. I don't particularly live at that one. I live at this one. That's why I gave them the address that I lived at. But I own both of the houses, so I just gave them both addresses, so you guys had somewhere to send the paperwork, either address.
Oh, since you have the address at First Street, that's the address we're going to use.
Okay.
Is that a 4? You have 2 4s in that address or 6 4?
Yeah, 4410.
Okay, so who resides with you at either of the homes?
My child's father.
Okay, and what about the children? Where do they reside?
With me.
Okay,
And
well,
my child's
who resides in the home with you? You said only your children's father, so I didn't know if they live somewhere different.
Oh, no, sorry.
And so are you on probation or parole anywhere, ma'am?
No,
Have you ever failed to appear in court for any reason?
no,
Are you out on bond in any other jurisdiction?
no.
If you were to test right now, what's in your system?
Nothing. But the alcohol, probably.
Have you ever failed to appear in court for any reason?
No, not that I know of. I mean, maybe when I was younger, when I was like 17, but no, not recently.
And you don't work?
I did work. My job laid me off, like I was trying to tell him, my job laid me off 2 days ago. I do have a lot of interviews and jobs. I just made a dumb decision last night.
And where was it that you were working?
Chrysler.
All right. The court having reviewed your criminal history as well as the nature of the charges in this matter. Having multiple addresses, the court wants to confirm that you're going to be appearing in court and that we can locate you if you do not appear in court. The court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed. All right, we'll see you back on May 21st. Thank you. Have a good day.
I'll put him in here.
Okay. All right, we're on the record in the matter of the city of Riverview versus Keon Thomas, 25346.
Good morning, Your Honor. Neil DeBlois here on behalf of Keon Thomas. Sir, state your name, right?
Keon Thomas.
Thank you.
Okay, hi. Hi, cutie. Sorry, for the record, that's not Mr. Thomas, that's the little girl he's holding. What's your name?
Carmen Thomas.
Aw. Okay, and so today is the date scheduled for the arraignment pretrial in this matter, and counsel as to the arraignment.
Yes, my client waives formal reading and stands to meet to the charge.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. Excuse me, as to the pretrial?
As to the pretrial, we're asking for a short adjournment. I think there's just a reinstatement fee that he was unaware of, that he needs to pay to put himself in a better position, and we'll come back and talk with the city attorney after he's able to do that. So I think it's just a misunderstanding. That's the court for 2-week adjournment.
Okay, and so the court will adjourn this to, you're here on the 28th, so we'll adjourn this to the 28th. Does that work for you, sir?
Yes, ma'am.
Okay. Allie isn't here, so I'm probably gonna mess up the docket time. I'm just gonna pick 10:15. Okay,
You said 10:15?
yes.
Okay, is there an earlier time?
Oh, we can do earlier.
Yes, as early as possible, please.
Okay, well, we'll do 8:45.
Thank you.
Okay. All right, then ask the bond counsel.
Esteban, again, this is basically a traffic situation. He understands what he needs to do to get this clarified. Came in today with no more prompting than a notice to appear. So I think he's well motivated. He is employed. He's obviously a dad, works at Ford Motor Company. He's well motivated to get this cleared up. And I think there's no fear that he'll come back. The personal bond will be appropriate.
Okay. All right, and so, sir, how'd you get here today?
My brother dropped us off. Her mom was supposed to be picking us up.
Okay, so you didn't drive here?
No.
How do you get back and forth to work?
Typically drive.
Okay, so you're gonna get your license back, right?
Yes, as soon as possible. I wasn't aware that it was still suspended today. I thought when I paid the ticket, it would at least like void the suspension, even
No,
though,
You're right, there's a separate fee with the Secretary of State.
he let me know, so.
Yeah, so did you drive here? Okay, I will say, that's the first I've seen it was someone saying no with their head and saying yes, so, okay. So, sir, you gotta make your other arrangements to get home. You cannot drive out of the parking lot,
Okay, so,
okay?
okay,
So, since you told me your child's mother was gonna pick you up, give her a call,
okay.
okay? And then have maybe somebody come with her so they can drive your car, but do not drive out of the parking lot.
Okay.
If you wanna get your license back, don't keep driving without a license, it's going to extend that even further,
Okay,
okay?
appreciate it.
All right, they will be watching, sir, so do not drive out of the parking lot.
Okay.
So if you end up driving out of the parking lot and you get arrested, can't say I didn't tell you. Really? All right, the court's gonna order a $5,000 personal bond, no driving unless you have a valid license. So in the event you, sir, decide that you're not going to heed my advice, or my order, I should say, and you're going to drive out of the parking lot, not only will it be a new charge, it will also be a bond violation. Okay, so do not drive.
Okay.
I can't be any more clear. All right, we'll see you back in 2 weeks.
All right, thank you.
Okay. Thank you, have a good day.
Waits outside for that?
Yes, we'll let you know, we'll let them know that you're out in the lobby. You're welcome. Okay, we are on the record in the matter of the state of Michigan versus Wendy Euphoria, 25657. And detective, your name for the record, please.
Detective Sergeant Devin Geiger, Wyandotte Police Department.
All right, thank you, Ms. Corrigan. May you have me step aside so the detective can stand at the podium, please? All right, detective, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter, the truth, the whole truth, and nothing but the truth.
I do.
Thank you, and you may proceed on the warrant.
On May 9, 2025, approximately 5:50 p.m., Wyandotte officers were dispatched to the area of 4th Street, New York Road on a report of a possible intoxicated driver. The vehicle was a black Ford Expedition driven by a female. Dispatch relayed the vehicle was almost striking curbs and other vehicles. Officer J. Cox and B. Smith located the vehicle on Goddard Road near 19th Street. Officers observed the vehicle swerve and cross the center lane into the oncoming traffic lane. Officer Smith initiated the traffic stop with a full marked patrol vehicle, lights, and uniform. Wendy Correa, the driver, was identified. Correa had slurred speech, and officers detected the odor of intoxicants emanating from Correa from her person. Correa admitted to consuming Captain, quote unquote. She consented to a standardized field sobriety test. While given instructions on how to perform the test, Correa stated, "I'm going to jail." As a quote, She then refused to do the test. Correa consented to a PBT, which indicated her BAC was 0.30. She was arrested for OWI. Correa refused the breath test, and a search warrant was obtained for a blood draw. While at the hospital to execute the blood draw, Correa became aggressive and resistant. Correa was advised of the search warrant. Correa was called the hospital staff derogatory names, attempted to pull her arms away from the staff performing the blood draw, and repeatedly told them they were not getting her blood. Correa attempted to kick Officer Cox and Smith in the legs and was restrained to a hospital bed. Correa was restrained by multiple healthcare professionals and officers in order to complete this blood draw. That's it, Your Honor.
All right, thank you. Upon examination, complaining witness, the court does find that the charges were committed as probable cause of the defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Neil DeBlois here on behalf of Wendy Correa, who joins us via Zoom from the jail. Ms. Correa, could you state your name?
Wendy Correa.
All right, thank you. And, all right, and so counsel adds to the arraignment.
Yes, my client waived formal reading and stands mute to the charges.
All right, the court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you cannot afford an attorney, you can have one will be appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court is going to enter a plea of not guilty on your behalf. Schedule this matter for purposes of the probable cause conference on May 22nd at 9:45 a.m. And counsel, as to bond.
Yes, as to bond, Ms. Correa is a 45-year-old. She's a mother of 3 children, 2 of which are in her care and custody, ages 14 and 10. Very important for her to ask me to point out to you that she's the sole caregiver for her 2 minor children, takes them to school, etc., and so forth. There is a ex-husband in the picture, but he is prohibited by a court order. He cannot have those children overnight. So she's essentially the sole custodial parent, according to the divorce decree. She has no criminal history. If you look on the CCH that's in the file, there's some incident up north that resulted in no conviction. She said it involved her husband driving illegally. And again, there's no criminal history here. She's never failed to appear for court when required to do so. She's not on probation or parole anywhere. And based on those factors, she also pointed out that she is gainfully employed with a company called Engler and Cartha. I can read my own writing. She's a medical assistant. She's been at that function for 8 years, but only a shorter period of time with her current employer. Again, so other than this incident at the age of 45, this is not a pattern of behavior that's shown itself prior to today. Ask the court to take that into consideration and allow her a nominal bond.
Okay, so Ms. Correa, I'm sorry, do you have 2 children or 3 children?
I have 3 children, 2 that reside with me that are minors.
Okay, and so where does your other child reside?
She lives with her boyfriend. She's 20 years old.
Okay, what city?
Wyandotte.
And counsel, I hear that she doesn't have any prior convictions, but I gotta tell you, the allegations are a 0.30.
From a little bit that I know on the record, that's extremely out of character. Yes, these are very serious allegations, and which we'll address. But at the moment, she's presumed to be innocent.
No, I understand that. I'm just making that statement because the court is going to indicate that your client is going to have an alcohol tether, because I have serious concerns for the safety of the public.
And I understand, Judge, if I may at this point, I'm going to make this request anyway. Can we have EMS in this particular case come in and do it? She's got to get back to these kids. She's very distraught about that. Again, 45 years old, no criminal history. And rather than send her to, county, which might be a week, I think that would, again, I'm not gonna argue that the tether wouldn't be warranted based on the allegations of the blood alcohol level. But how much more security would it be if she has to wait a week in jail to get the tether provided by the county?
Well, who's been taking care of the kids while she's been in jail over the weekend?
I do not know.
Ma'am?
He had them overnight last night. I had to let him because I had no one else take them.
And so
And I haven't even been able to talk to him. I haven't been able to talk to anybody.
yeah, there's a court order that says that the children are not to be with their father.
There is, until he secures his own home with a bedroom for each child.
As I
And this
understand,
has been,
not that he's a danger to the children, it's just that it's got no visible means of support and has no steady place to live.
Okay.
That's,
All right. And so your daughter can't help out with the children?
she works and goes to school. She doesn't have time. Please, Your Honor, I know I messed up. I need to get home to them.
Ma'am, and you also need to maintain sobriety and protect yourself.
I promise, I will, I promise. I learned my lesson. I am fully remorseful and I apologize for my actions and behaviors.
I mean, the level alone is alarming. The level alone is alarming. What's most alarming is that this seems to be your first offense.
But well, CPS is gonna take my kids. I can't have that, please.
Why is CPS going to take your children?
If I'm not home to take care of them.
Well, ma'am, they do have a father who apparently is not a danger to them, but doesn't have the means to have them on a full-time basis.
He's not hands-on. I've asked him to help take them to school before and he says he can't call off work. I've asked him to help take them to doctor's appointments and he says that it's too inconvenienced. I should have told him sooner. Well, I'm sorry, but they're your children and you should help out. So I lost my previous job because I had to call off work so many times to take my kids to pick them up from school or take them to the doctors. And that's why I've now been in private practice for the last 7 weeks because I had to find something part-time.
Oh, 7 weeks or 7 years?
I've been in the field for 8 years. I had to leave my previous job of 6 years because of my ex-husband not helping with my children. I would have to leave work early to pick them up. I would have to call off of work to take them to the doctor.
So you've been at this current employer for 7 weeks?
My current one for just about 7 or 8 weeks. I just started this job.
Okay, ma'am, and I can understand and appreciate that you have those stressors. However, my responsibility is to protect the community. So one way that that's going to be accomplished is through an alcohol tether through Wayne County Jail. Now, the reason I'm going through having the Wayne County Jail is in the event that your client violates that, they're going out to arrest her immediately. And I think that your client needs that additional level of enforcement to make sure that she's maintaining sobriety for the safety of the public. So the court's going to order a $30,000 personal bond. You're not to possess or consume any alcohol or drugs unless prescribed. If you were to test today, ma'am, what's in your system?
Your system. Do you have any drugs or anything in your system?
No, nothing.
Okay, all right.
I don't use drugs.
Any medication?
Oh, I take Boost Bar for anxiety. I take Lexapro for depression. I take amlodipine and hydrochlorothiazide for blood pressure.
Okay. All right, ma'am, we will see you back on May 22nd. So, I'm just letting you know, ma'am, what's going to happen is that you're going to take the ride down to Wayne County Jail. They're going to get you fitted with a tether, and then you can be released. An alcohol tether.
No, Your Honor, I thought that This is not a felony, Judge.
Yes.
Are you gonna send an order?
You know what?
Every day in the USA, people find themselves in court.
All right. We are on the record for the 28th Circuit Court here in Westford County once again today. Our next case here is People of the State of Michigan versus Jesse James Hotbit. This is file 24-13861-FH. Please.
Joanne Carey for people. Ashley Siegel for Mr. Hotbit.
Ms. Siegel appears today via Zoom, and also Mr. Hotbed appears via Zoom separately from a Department of Corrections. Hotbed, are you able to see and hear us, sir?
Yes, I can, Your Honor.
Also here before the court this morning is Miss Lindsay Simmon, the probation officer that was assigned to the case and prepared the pre-sentence investigation report. We were last here on the record in this file back on December 9th of 2024. The defendant had been convicted at a jury trial of operating while intoxicated as a third offense with a second habitual offender notice. The court sentenced the defendant to a prison term of 18 months to 90 months with looks like 206 days of credit, and the court had talked a lot about on the record putting the defendant into or granting the defendant SAI boot camp if eligible. There has been a motion filed by Ms. Siegel on behalf of the defendant. I have gone over that motion. It was received in our court back on April 28th. Ms. Carey, while not necessary, did you file a written brief? I just want to make sure I didn't miss something.
No, we did not.
All right, thank you. I'm going to turn the floor over now to Ms. Siegel. Ms. Siegel.
Thank you. Good morning, Your Honor. So to summarize our motion and brief simply, the court made several references to its intention was that Mr. Hotbit would spend about a year in jail or a year incarceration and that he would get treatment. As we stand here today, Mr. Hotbit has done 360 days time served, and he is not eligible for parole for at least 6 more months. So that's as we stand today. And I also would like to confirm that the court and opposing counsel have received the proof of treatment that Mr. Hotbit has received in MDOC that I sent last week.
Yes, that was received in my office, I believe, on Wednesday, May 8th. I have reviewed that. That again is the Advanced Substance Abuse Treatment Program regarding Mr. Hotbit.
Thank you.
I believe it was 3 or 4 pages, 3 pages. 2 pages with some, I guess it looks like they're AA group attendance sheets. Yes, I've gone over those.
Yeah, thank you, Your Honor. And I'd like to say,
hold on one moment. Ms. Carey, why don't you go ahead and come up here and you can grab my copy. It's a very short, quick read.
Thank you.
Thank you. Ms. Siegel, I'm going to give Ms. Carey just a moment here to take a look at that, and then I'll return right back to you for further argument.
Thank you, Your Honor.
All right, motion carry has taken that opportunity to review the document, returned it back to me. Ms. Siegel, you may continue.
Thank you, Your Honor. So I'd kind of like to, first of all, I'd like to point out that I believe that the NA and AA, the reason that they only go back to February, I haven't confirmed this with Mr. Hotbed, but I would guess because that's when I first told him, hey, if we're gonna go back for a resentencing, you might want to start documenting your attendance. So I would guess that possibly he attended prior to that as well. But I had just started to ask him to document that once I met with him. So oh, sorry.
I'm sorry. I understand it's acceptable. Thank you. You may continue.
Thank you. I'd like to work backwards then, and say that as we stand here today, Mr. Hotvet has had 360 days of time served between the county jail and MDOC. I would also like to point out that he is involved in NA and AA classes. And then if the court could reference what's called the ASAT, the Advanced Substance Abuse Treatment Midterm Treatment Report. If you look at the comments on there, and I know these are more comments that I'm making right now is if we were in a resentencing, but if the court would indulge me for just a moment, I'd like to point out that the X marks are all like good as far as how he's doing.
One moment. Mr. Hotvet, do you know how to mute your your audio over there?
Yes, I do.
Would you just please do that? But when you do that, one, raise your left hand and let me know you've done it. And two, wave your left hand and let me know you can still hear me.
Okay.
Thank you. Can you still hear me? Can you? All right, good. He can hear me. Thank you, Ms. Siegel.
So I'd like to point out that he has the X marks are under good for everything. And I don't know what it would take to get an excellent, because when you read the comments, it says that he has only one excused, he has one absence that's excused, consistently on time and prepared, positive attitude towards treatment, participates, offering personal disclosures, provides feedback to other group members, receptive to feedback, his homework is well done, and then demonstrates internalization of concepts, making progress towards his goals, behaving in a pro-social manner, identifying negative thinking patterns. So he has good, but I don't really know what it would take to get excellent, because those comments look pretty excellent to me. So the reason I point that out is because the court at sentencing was mostly concerned with having Mr. Hotvet spend about a year of incarceration and with him getting treatment. And he has done that. And the court was laboring under a misconception or a misunderstanding at the time of sentencing that was not caught by either of the parties. And I did make a motion in here, in my motion, I did make a request for relief under ineffective assistance of counsel, because there was no reason, purpose for Mr. Hotvet's defense counsel at that time to not speak up and let the court know that he is charged as a habitual second offender, and that makes him a boot camp ineligible. To be fair to MDOC, Miss, I think Simmons, she also indicated that he was not boot camp eligible. And I'd like to just give her a little bit of a pass, because the PSI, their recommendation kind of indicated that they were recommending and anticipating jail time. Their recommendation, they recommended 3 years of supervision with a term of incarceration as determined by the court. And of course, that could include MDOC. But the next sentence, it says, if approved, the defendant may be considered for early release from incarceration for residential treatment. Well, the court only has authority to early release if he's in jail. So I would say that when Ms. Simmons was working this case up, she was anticipating and recommending jail time. Now, Your Honor, thought, well, he could probably get better treatment and maybe even get out earlier if he went to jail and had boot camp. And like I said, at that time, his attorney did not inform the court that he was not boot camp eligible. So a person does have a constitutional due process right to be sentenced on accurate information. The right of due process is guaranteed by the United States Constitution and the Michigan Constitution. And we have case law that says that for sentencing to be to provide somebody due process, that the sentencing information must be inaccurate. So there was inaccurate information at Mr. Hotvet's sentencing. There was ineffective assistance of counsel that that information was not corrected. And I also believe that the court's desire for what the court's anticipation and desire for what Mr. Hotvet would serve and what his sentence would be was not carried out because of this misinformation. So today our relief that we're asking for is for resentencing. And actually, ideally, as we sit here today, given that Mr. Hotvet does have 360 days of time served, I would ask that court to move the court to and waive any kind of notice and waive appearing in person, waive Mr. Hotvet's appearance in person, and ask the court to hold that resentencing today. And I don't think that there's any other argument I would have to make or any other evidence, any evidentiary testimony that would have to be placed on the record for that to happen. So that's a relief we're requesting today, Your Honor.
All right. Mr. Hotvet, please turn on your audio. Are you able to hear me?
Yes, Your Honor.
Mr. Hotvet, you have the right to be physically present in the courtroom whenever the court issues a sentence. If I do grant the motion to allow resentencing, do you waive that right to be physically brought here before the court and allow us to conduct sentencing today as requested by your counsel?
I do, Your Honor.
All right, thank you. Now, before I make any rulings, I'm going to turn over to Ms. Carey. Ms. Carey, any argument at least to initially the motion to resentence? Okay. All right. The court therefore finds that there was a misunderstanding, and I think it was compounded by everyone here in the courtroom, including the Department of Corrections, as to the defendant's eligibility for SAI boot camp. Therefore, based upon that, the court will grant the motion for resentencing. And based upon the request by Ms. Siegel and the waiver by the defendant, be physically in person, we will conduct that sentencing now. Ms. Siegel, do you have anything further to add for allocution?
It's
Hold on. Mr. Hotvet, we're going to do the same process. Go ahead and mute it. All right, so you did. Now, can you wave your hand? Can you hear me? Thank you. He complied. Ms. Siegel, allocution.
okay, just a few things that I'd like to add at a motion for resentencing. The time served of 360 days, the treatment that Mr. Hotvet, I'd like the court to take notice of the treatment that he availed himself to in the county jail, which was mentioned at his original sentencing. It wasn't very much because there was only a certain amount of availability, but he did take advantage of that availability at that time. He's also taken advantage of the availability of treatment in prison and has a very good report of that attendance. He does have a plan upon his release to continue in therapy. He has a supportive, sober supportive, sober family. I believe his dad's probably present in the courtroom today. I don't know if he is, if he wants to wave or something, because he's been very involved.
I recognize it.
Okay. And there is a plan to continue therapy and AA upon his release. He has work lined up and a clean and sober home to go to upon release. And he also said that he was working diligently through that ASAP program. At the time of the report, that was the midterm, and he had completed 16, I think, out of 38 sessions. And he said by the time of today's hearing, he should have 33 out of 38 sessions completed. So with that, I would ask the court to sentence Mr. Hotvet to a term of incarceration of 365 days in jail, and whatever else the court determines. And I would also ask the court to inquire of Mr. Hotvet if he has anything he'd like to.
All right, thank you. I will get to Mr. Hotvet in just a moment. Just to confirm, Mr. Hotvet, can you raise your hand? Are you still able to hear us? Yep, copy that. Thank you. Ms. Carey, allocution, anything further to add?
Thank you, Your Honor. If the court does release that, the people would ask for, given the circumstances of this case, people would ask for an extended term of probation along with current time served. Thank you.
Thank you. All right, Mr. Hotvet, you may now turn your audio back on. This is the time where you have the right to make a statement if you choose to do so, sir. Is there anything else you wish to say today, Jesse?
Yeah, just a little bit. I'll keep it short. Your Honor, I'd just like to include the fact that I've remained ticket-free this entire time. You know, I've had no issues with substance abuse. I've attended AA from the day that they finally allowed me in. And I've, obviously taken my ASAT, my therapy seriously, and I've really strived to not only help myself, but try to help others in that class. And I think my teacher would agree with that. I have a really good plan for upon release. I have a good, safe place to go. I have work lined up, and I plan on just getting out and turning my life around. And with that, I'll leave it at that.
All right. Thank you. Give me just a moment here to gather some thoughts. All right. I'm going to make some comments, and Ms. Siegel, one of them is going to mention you. Please keep in mind there, I do not mean anything negative by that. Now, by the way, once of course someone says that, they think, oh my God, that judge is going to say something negative. No, it's really because I need to take some things that people say, and I need to explain and address them so there's never a misunderstanding. The one thing that you said that I would take a little bit of judicial issue with is, it's not a big deal. The Department of Corrections might anticipate, but I'm going to tell you that I'm pretty certain that the probation and parole officers who come here do not anticipate I will follow them. So they know, and I'm very protective of this. And the reason I mention this is I'm very protective of judicial discretion. Not everybody politically in this world today seems to be, but I am. And I don't get to say, hey, here's what I think about a case until it comes time to sentencing. That's my discretion. The Department of Corrections, whether they are local or they are in Lansing, has no authority over my discretion. They are a separate branch of government, and if they ever make a sentence and they think they should anticipate it, they have a second thing coming. They have another thing coming. That's not me. That's not their job. They get to put out their opinion, and I treat it equally as if it's the prosecutor or the defense attorney. So again, I'm not saying that to swat at you. I'm just saying that for the record as a judge who believes in judicial discretion, and that's when I apply it. So, and I also, by the way, know that sometimes there's pressure put on local probation and parole officers from Lansing. And that's another reason why I take their opinion. I strongly value it, but I make the determination on the sentence, as does every other judge. Now, in this particular case, also when the court gave a sentence, it's a difficult balance for a judge as he's trying to hammer out 10 or 15 cases for sentencing all in a couple hours on Monday morning to establish proportionality and reasonableness. And also try to set a positive tone, especially if the defendant has been found guilty, either by plea or even by a jury, because they often feel defensive and attacked. And so I try to be really positive. And that's what I was trying to do when I had talked about boot camp, trying to establish some positive nature to give the defendant an objective on making forward progress. Some defendants, let's say it was a more serious, like a violent felony or a drug dealing case, they might go to a prison sentence and just do nothing and just sit there. Well, I want to be able to give the defendant, especially Mr. Hotbed in this instance, an objective so they can use their time effectively. And that appears to be what Mr. Hotbed has done, even if when it was found out that there was an error in interpreting his eligibility for boot camp. So I commend him for his activity. The court also, whenever establishing a sentence, must establish the reasonable proportionality for the sentence, or at least the reasons for it. In this particular case, I just need to highlight some things. And if I were in Mr. Hotbed's position, he might feel the judge is hammering me on things. Well, the law says I got to cover these. So then I have to establish the reasonableness and proportionalness. Well, you know, this case here was an instance where the defendant, when he was asked about having a driver's license registration, proof of insurance, he said no. When he was asked to perform sobriety tests, he said no. When he was given another chance to perform them, he said no. When he was asked to take a preliminary breath test, he said no. He was found out on a back road here in northern Michigan, here in Wexford County. And to say he was drunk is an understatement. He had a 0.283, over 3.5 times the legal limit. And even more important, and one of the more important elements is, and I highlighted this, it said that during the intake process, Jesse threatened deputies by saying, the next time we'll see if it doesn't turn into shots fired. Wow, that right there is what set the tone for me. But also at the sentencing, I had to establish a positive tone, give the defendant some encouragement. So his conduct was not only illegal, but it was atrocious based upon his conduct toward the officers throughout the entire process at his blood alcohol level. While he had some prior criminal history and some of it was close, he did have some successes on probation. But he did have one instance back in 2018 where he made it 4 days between one sentence and the next case. Then he made it 7 months between that and the next case. And in this file, he made it a little over, or just about 1.5 years. So I had a defendant who was committing some repetitive conduct while not an overly extensive criminal history. It definitely gave concern to the court. So, but in that, I do note that I wanted to try to, I don't want to use the phrase shock and awe isn't appropriate. I wanted to change the treatment of the defendant and put him in a new place that would give him new objectives and opportunities to be successful. And Mr. Hotbed has done just that. He has used his time effectively, and I'm very proud, I'm very glad to see that. The information contained in the advanced substance abuse treatment midterm report that you provided, Ms. Siegel, I found to be very helpful. I don't often see those. In fact, very, very rare. I probably have only ever had a couple of those presented to me. I do appreciate that. So we go back to the time in which the court issued its sentence, which was back on December 9th. Ms. Siegel, could you again confirm for me the number of days that he has for Ms. Simmons? Do you know it?
360, I believe she said.
I just want to make sure it was 360. That wasn't just a rounded number. It just seems odd that it happens to be 360. That's all. Is that right, Ms. Siegel?
Yes, Your Honor. Yes, it's 360 days.
Mr. Hotbed, is that correct?
As far as my understanding, yes, Your Honor.
All right, thank you. What did I do for fines and costs? Did I have? Oh, I guess I could look that up. It's kind of lazy for me to ask the clerk.
You did the standard ones.
Standards?
And the prosecutor, OWIP.
Yeah, okay, great. All right. This court reassesses all the fines and costs and restitution fees that were previously set by this court. The court will place hereby sentences the defendant as follows. In addition to its statement a moment ago about fines and costs, the court will place the defendant upon a period of probation for 36 months, which requires the court to add a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. The court therefore must establish terms and conditions. Well, the court adopts the original terms and conditions that are listed on CFJ 145 pages 2 and 3 of the original pre-sentence investigation report that was signed by this court again back on December 9th. And I find that those terms and conditions are well suited for rehabilitative purposes. I'll note that it includes 480 hours of community service, and the court continues to order that. There's also a notice on there for the SCRAM program. Ms. Simmons, do you feel that that's still appropriate?
At this point, Your Honor, not necessarily.
All right, then I'm going to strike line 9 and remove the SCRAM tether device.
Thank you.
Thank you, ma'am. And you know what? Let's go ahead and take that community service. And even though I said 480 hours, which is what was originally listed, I'm just going to make that 120 hours.
Thank you, Your Honor.
The court sentences also the defendant to 365 days with 360 days of credit. In other words, I believe that this is reasonable proportional, even though I think a prison term could be appropriate here. I'm also taking into consideration that the defendant has complied in effect with all those objectives that the court set out for him. And I'm glad that he's done so. I will note here for the defendant, his conduct was quite atrocious. I hope that he has taken the opportunities to better himself here over the last 5 months in the prison. All right, Mr. Hotbed, you have the right to appeal your conviction and sentence based upon the fact that it was by a jury. You have the right to file a claim of right to appeal. If you choose to file a claim of right to appeal and you wish to have the court order or appoint further appellate defense attorneys, you may complete the bottom half of that document and return to the court within 42 days. Please note that all fines and costs are due within 52 days. 59 days. 6 hours to get there. You know what? I should circle it. There we go. I'm going to circle it right now. It's 56 days. And if you fail to pay within 56 days, a 20% penalty will be assessed. All right. Have I missed anything else, Ms. Simmons?
No, Your Honor. Thank
Ms.
you.
Carey?
No, sir.
Anything else, Ms. Siegel?
No, I would just ask that when Mr. Hotbed is released, that he would stay in contact with me because my appointment does not expire today. We still have other things we need to do to either, if there's any other issues, I'm still appointed for that, or to end my representation. I need contact with Mr. Hotbed.
Ms. Siegel, the one thing here is if you could please just draft an order that says the court granted the motion for resentencing. And then
Your
I'll
Honor,
sign that.
I did forward proposed orders granting and denying.
Hold on. 1 second. All right, I see that order. Thank you. I will sign that. Thank you. I have signed the one that specifically says grant. Anything else today? Thank you.
Nothing else, Your Honor. Thank you.
Thank you. We're adjourned. You. The next case is people of the state of Michigan versus Javier Castaneda. There are actually two files here. File numbers are 24-13980 and 13981. FH. Appearances, please.
Good morning, Your Honor. For the people on both files.
All right, so again, that's Michael Dobie on behalf of the people on both files. He is an assistant or special assistant attorney general. Mr. Burdett, go ahead, I'm sorry.
Oh. Yeah, Bill Burdett appeared on behalf of Mr. Castaneda.
All right, thank you very much. And Mr. Castaneda is currently in pretrial custody. He is now here seated next to counsel. The court also recognized before it this morning Mr. Stephen Saladay, the agent from the Michigan Department of Corrections, who prepared today's pre-sentence investigation report. We are here today for sentencings on both of these two cases. In the file ending in 8-0, there was a plea to a flee and elude in the 4th degree. And in the file ending in 8-1, there was a plea to delivery of a controlled substance, narcotic or cocaine less than 50 grams. The court received and reviewed the pre-sentence investigation report. I'm going to take a quick look here and see if I had any potential changes. As I look through the prior criminal history, I do try to take note. I always cross through, or recently started crossing through on my copy, any that were dismissed. So I just want to ensure the defense counsel know that those are not considered today by this court, even though they're listed in the PSI. One moment. Looks like the first thing, or maybe the only thing that I caught, is we need to change the sentencing date that was originally scheduled to occur on April 28th, and today is now May 12th. That should also impact the defendant's credit that appears on CFJ, or at least is calculated on CFJ 145, page 2. Obviously, he does not get credit for today because he'll receive credit by the end of the day. So we have to add 11 days for May, and we need to add 3 more days for April. So that's 14 days. So we'll have to change the date range, obviously, from April 27th through May 11th, 2025. That gives the defendant 199 days of credit, which will have to be noted on other cases within the report. Okay, other than that, let's turn over to the people. Mr. Dobie, do you have any amendments, corrections, or objections that you wish to make or note for the court?
Your Honor, I did speak or by email with Mr. Burdett. I understand that he's going to have an objection, I believe in both cases, to OV 13. Which is currently scored at 25 in both cases. I would be conceding to that. OV 13 should be scored at 0, as neither of these the crime types could be part of a pattern, result in scoring 25 points.
All right, well, you're probably stealing Mr. Burdett's thunder, so hold on just a moment. It's okay. Before we get to that, any other corrections inside the report, Mr. Dobie? Let's just say besides the points. Okay.
No, Your Honor.
Thank you. All right, Mr. Burdette, let's go ahead and let you thunder away here at
Okay.
OB 13.
Yes, Your Honor. And in the Supreme Court case of People versus Nelson, 491 Mitch 869 2012, the Supreme Court remanded the case back to the Court of Appeals on the issue of OB 13. OB 13, you get 25 points if it's a continuing, if the case is a continuing pattern of criminal behavior. In the dissenting opinion that the Michigan Supreme Court adopted, the dissenting opinion in Nelson indicated that the crime itself has to be like a person or a property to be part of a continuing pattern of criminal behavior. In Nelson, it was a controlled substance case, and the Michigan Supreme Court would remanded and said you couldn't score OB 13 for controlled substance because it wasn't a pattern of continuing behavior of a person or a property crime. And the same would apply to the fleeing and looting because that's a public safety. So it should be 0 on both.
Thank you. And I've already heard Mr. Dobie's argument, and I'm going to take a quick look here. And the CFJ 284 probably should be page 2 or 3. Looks like page 2. 1 second. Okay. All right. The court agrees with the parties and will strike offense variable 13 from 25 points down to 0. That reduces the total OVs from 45 down to 20. And I'm going to take a quick look. Well, you probably all know what it does. Sure, it reduces that down to probably a 2. Let's take a look. That brings it down to an offense variable level 2 for the file ending in 8-1. And then when we look here at the second, we're going to reduce the OV 13 25 points. That brings that total OV down from 55 down to 30. Class G offense, wouldn't be surprised if it doesn't change it, and it does not change the OV level, and does not change the minimum guideline. Mr. Burdette, anything else?
Yes, Your Honor. On OV 14, it scored as in the controlled substances case, was it scored by client as a leader in that case. And I know when you review the pre-sentence report, which is based off interviews of my clients with the police officers, he indicated that he was told to come off the Cadillac to sell the drugs. Therefore, he was not a leader in this instance. He was just a follower. And I think that the 10 points should not be scored for OV 14. If the court does grant that objection, it doesn't change the guidelines. Then the OV 13 is 0.
All right. Mr. Dobie, your response to that argument, sir.
Thank you, Your Honor. OV 14 is properly scored in this case, and particularly the crime that's at issue here is the delivery of cocaine. In that situation, the defendant had employed a Mr. Bryant as a driver who was just given instructions to drive to various places where Mr. Castaneda was committing these deliveries of controlled substances, in this case the cocaine, and he was questioned, and that evidence is in the report. Though Mr. Castaneda claims, and that claim can be true, that he was distributing at the behest of someone else, there can be more than one leader if we've got 3 people, and under the argument put forth here, we would have 3, an unknown person above Mr. Castaneda, and then Mr. Bryant, who is acting at the direction of Mr. Castaneda.
On CFJ 284, page 4, there is a paragraph toward the bottom that begins to talk about, it says, quote, Mr. Bryant was interviewed, end quote, and it continues. I'm just using that quote to identify the paragraph. Specifically, I looked at, and while there's a lot of information here on this page, it talks about how Mr. Bryant said that Mr. Castaneda would pay, quote, pay him to drive him around, and he was getting $100 for driving him up to Cadillac on October 15th, 2024, and $200 for driving him up to Cadillac on October 23rd, 2024. And I'll note here that it sounds, at least while I don't necessarily think I believe Mr. Bryant, because I've dealt with Mr. Bryant on his side of this case, he said he did not know what Mr. Castaneda was doing. I will say that the court finds, based upon a preponderance of the evidence here, and in fact, I think he even goes further than that, on the information contained in the PSI, that the defendant, while maybe being the second, and possibly a second in command, but he definitely was one of them in command. Somebody else may have told him to go do something. I liken this to a military example. If the general tells me as a lieutenant colonel, march your troops in that direction and go take that hill, that's my job, and I'm a leader of the other troops. Here in this particular instance, I have zero doubt that Mr. Castaneda is a leader in this adventure coming up to Cadillac, not once, but twice, apparently, to be a drug dealer. So the court denies that challenge for offense variable 14 and leaves it scored at 10 points. Thank you. Anything else, Mr. Burdett?
Just one typo on page 2 under additional information.
Yep, 1 second here. All right, I'm there.
It says PRV 2 is scored at 0. It should be 20.
Oh, okay, thank you. And I do see that it's actually scored as 20. So thank you. We'll make sure that that gets changed. Anything else, Mr. Burdett, before we turn to allocution? All right, thank you. Allocution, sir.
Yes, Your Honor. My client has spent 199 days in jail on this offense, and it's been kind of a wake-up call for him. He's been speaking with his mother, and his mother has enabled him to possibly get a job and work with her, and he plans on moving in and living with her while he gets his life back together. He realizes that, you know, when you look at his prior record, and I've also explained to him as well, that, you know, as a young man, his record is going to start driving anything else that happens to him. Even something as mundane as, you know, even a low-level felony is going to be driven by the guidelines, and it's going to basically tie the court's hands as to a minimum sentence, because it's going to be starting to be prison time after that with no discretion. He realizes that he does not want to go to prison, Your Honor. He's currently working to get his to get a high school diploma. He's working with the Muskegon Covenant Academy. He's going to start doing that as soon as he gets out. To get a high school diploma and to better himself. But we're requesting the court, Your Honors, to sentence my client to a period of local incarceration. He's already spent close to 200 days already in jail, and put him on probation with this court. If the court feels that a prison sentence is recommended in this case, then we're just requesting that they consider boot camp for Mr. Castaneda. I mean, I believe he qualifies for that. Thank you.
Mr. Goby, on behalf of the people, sir.
Thank you, Your Honor. Keeping in mind that the adjustment of the sentencing guidelines does put the recommended sentence significantly above that, I still believe that this is a case that a prison sentence is appropriate, and so would be recommending that here, Your Honor. And regarding the request for boot camp, he does appear to be eligible Nothing that I saw stands out that he would be ineligible. I would simply leave that to the court's discretion.
Thank you. Mr. Castaneda, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today, sir? All right. Also note another reason for my ruling before, well, I didn't state it regarding offense variable 10, I believe, was that on CFJ 284, page 5, where it does say that the defendant was told to do something and therefore wasn't the leader. I don't believe him because I tell you, it says here, he was up, it says, he told the officers he was up in Cadillac to get money, but would not say what the money was for. He then said he would drop packages off, but didn't really know what it was. And then when he was told when he was asked to say by whom, he wouldn't say. So therefore, I don't really have any evidence that he was doing it for somebody else. Now I can say that I've seen a lot of these files, Mr. Castaneda, from young men like you from Muskegon. When you go back and you're going to go to prison, you can get on the phone and you can tell these people who are telling you to come up here and other young men like this, don't. I don't care if he sends up, because I've started to figure this out. They start sending up 18 and 19-year-old kids. Those 18, 19-year-old kids are coming up here because they're being talked into it. You're not an 18 or 19-year-old kid. That's why I really think you're probably the leader or one of them. Drug dealers are spreading poison, and that's what you were doing. You knew it. You were intentionally doing it, and you were intentionally working with somebody, and even according to your own comment there, to bring it up. Well, when that happens, drug dealers, like in this instance, need to go to prison, especially when they've got a scoring like this, when the guidelines are not mandatory. I almost have to say that these days, because I acknowledge that they are, the sentence is still discretionary. And if you know any other young men who are doing this, you can tell them that they run the risk. When they get caught here, it doesn't go as well as they think it will. You lied to law enforcement here. You knew, I think it's clear, you knew what you were doing. You intentionally had your, I think it was a relative here, cause Mr. Bryant, to come along. He had to go get a car from Grand Rapids, if I recall, to come drive you around so you could deal drugs up here, an hour and a half or 2 hours away from where you live, to come up here. And you didn't deal just an ounce or a gram, I mean. You got an ounce and then 30 grams the next time, which is over an ounce. On behalf of the people here in Wexford County, you're going to go to prison. I think it's fair. I think it's reasonable. I think because of here, you're clearly lying. And then you were leading on people, the police, on a high-speed chase reaching 110 miles an hour. Putting people at risk. Were you doing 110 miles an hour because you thought you were delivering a cupcake? No. You're not smarter than what you think you are based upon what I've read that you told these officers and how you treated this. 110 miles an hour, putting people at risk. Speeding in a 25-mile-an-hour zone, although it was only 37, not that that's, I should use the word only, but you continue to accelerate. You got out to the freeway. You must have seen way too many TV movies or TV shows and movies. Your criminal history began as a juvenile. You started off with some domestic violence back in 2016, and you had multiple probation violations, which tells me you don't follow instruction well, and you just do not care. You were given chances and you violated. And then between that, you made it a year before you picked up new charges. And this time, lo and behold, you went to guns. And then By the way, that was within. Yeah, oh, in that first file, you didn't even make it a month before you started violating probation. Well, anyways. You had a couple that were dismissed, and then you picked up one more as a juvenile. And lo and behold, flee and elude, resisting police. So you already set this from the beginning. So in this time when you fled, you knew what you were doing because you'd done it before, got caught before, and got punished before, but you didn't learn your lesson. Now, I do understand that you are a young person, 20 years of age, but you are already not a first-time offender, not a second-time offender, not a third-time offender. And whatever the other courts have been doing for you over in Muskegon, you have thwarted it. In 2020, as an adult, you were given HYTA. You have thwarted that and lost it because you violated your terms or conditions. That was rejected. And of course, it's your first offenses as an adult were resisting police officers. Then on your second entry as an adult, you picked that one up while on bond. And I just went to a conference last week and they had a session that talked about bond and how we're supposed to make everything great and easy because we all want you to survive or do well. We do. And here you thwarted that opportunity. And there you go when you pick up a malicious destruction of a building. And of course, your HYTA then was revoked because you made it a whopping 5 months on probation before you picked up another charge. By the way, that case resulted with assault with a dangerous weapon. So, more violence, guns, opportunities, probation violations, bond violations. Between your third and your fourth adult cases, looks like you made it just about, I'm sorry, actually, yeah, not even a full year, but only 2 weeks shy of making it a year. And you were back to acts of violence because you got another domestic violence. Number 5, this one occurred while on both district probation and circuit court probation. And this occurred within 6 months. And this one is what you get here for the flee and elude. So in this file, you're on probation for 2 different courts for both of these files. So every opportunity that you have gotten as a benefit because of most likely your age, it hasn't worked. So people will say that because you're under the age of 25, we're supposed to acknowledge that your brain isn't fully developed. And I agree, it's not. But I'm going to tell you, whatever Muskegon has tried is not working. So, also another thing, another reason why I didn't believe you as far as you weren't a leader, because when it talks about gang involvement, you don't have any, which means you're not with a group of people helping do this. Maybe you are, I don't know. You've got a daughter, you're 20 years of age and you've got a 5-year-old daughter and you've decided that to help maybe support your daughter, you're going to do it by dealing drugs and being a drug runner. I saw this one thing out here about your work employment history. It says since 2023, you've been involved in maintenance. You don't know who you're, it says unknown employer and unknown if you quit or I found that one kind of funny. I didn't know what that meant, Mr. Saladay. He either does work or he doesn't work. And if he does work, he doesn't know his employer and doesn't know how much he makes, doesn't know if he's quit, doesn't know if he's been fired. That ain't much of a job. You decided not to finish high school. That's unfortunate. Well, the place we're going to send you today helps you get your you've been using marijuana since you were 13. So, that's not good. By the way, if you're using marijuana but not using methamphetamine, that tells me that you're willing to peddle the drug that you don't use. Maybe because you recognize that it's a bad drug to be using. You've had some treatment, and looks like you completed an intensive treatment program. It says that he has post-traumatic stress disorder. What's that from, Mr. Hart, Mr. Burdette, do we know?
I don't know, Your Honor.
Yeah.
To be honest with you.
All right, I appreciate that. Well, the defendant didn't talk about it. I don't have any medications listed. I don't have any treatment. I don't have when treatment began. I've got nothing to support that. And here's another thing. When I look at child support underneath liabilities, the defendant doesn't even know how much money after 5 years of having a child, how much money he's supposed to be paying for child support. What is he doing to help take care of his daughter? Well, being a drug dealer isn't going to help you. So now I'm sitting here looking at this sentence, and I've got to decide what is an appropriate sentence. Part of me says that these guidelines do not apply. They're not mandatory. It's funny that they're not mandatory, but I still have to talk about them. And if I exceed them, then I've got to give reasons. And if I exceed them, there's going to be an appeal, which there can always be an appeal. But so what do I do? The court assesses on file ending in 80, $68 state minimum fee, $130 crime victims' right fund fee. I'm just going to set a $150 court cost, a $250 fine, a $150 attorney fee. And do we need DNA here? You lost Mr. Dobie. You know what?
I'm not sure where.
Is he
lost
there?
him at. No.
All right, well, never mind. The AG's office doesn't want to be here. I'm sure it was an accident. I'm not trying to pick on the AG or AG's office.
Okay.
What's that?
He's coming back in.
All right, let's come back in. All right, Mr. Dobie is now joined us again. Mr. Dobie, I know we lost you there for a moment. Let me take a look. Does the defendant have any prior felonies here, Mr. Saladay? Do I need to order a DNA fee?
He's on felony probation.
Oh, yeah, so I shouldn't have to order a DNA fee. All right. So on this file ending 80, the statutory maximum is up to 24 months pursuant to the 2/3 rule. The highest the court can go is 18 months. The court therefore sentences the defendant to a prison term of 18 to 24 months, and the defendant receives 199 days of credit. In file ending in 8/1, the court assesses another $68 state minimum fee, another $130 crime victims' right fund fee, another $150 court cost, another $250 fine, another $150 attorney fee. Again, no DNA fee necessary. In this particular case, which is the charge of delivery of controlled substances, and if I got this wrong, by the way, I may have said methamphetamine. I know if this was a narcotic or cocaine, which, by the way, now appears to be the new. Oh, wait, well, there was also methamphetamine. Was it cocaine? Let me make sure I got this right. Oh, yes. He had the 1.5 grams of cocaine. Bless you, ma'am. He had another 5 grams of something that wasn't was inconclusive for testing. But in addition to that, this defendant is bringing up here the 31 grams of meth and the ounce of meth, another one for an ounce of methamphetamine. One moment. So not only am I sentencing him here, I'm also finding that the guidelines. Wait, do we have a guideline that talked about trafficking in here? I mean, it wasn't an aggravated drug offense because of the amounts, right? No. All right, well, then the court finds that based upon this offense and the conduct of this offense, the guidelines are inadequate. They do not score and account for the fact that the defendant, which this court finds, was also delivering methamphetamine in the amounts as I previously discussed. That again, the guidelines are in effect are inadequate. And I find that in addition to being a cocaine dealer, there's probable cause, or sorry, there's enough, preponderance here to find that he was also bringing up the methamphetamine. I'm just going to take a moment to review the PSI again, specifically CFJ 284, page 4, before I continue and announce the sentence. Yes. While the defendant did not plead guilty and was therefore not found guilty of the other controlled substance delivery, we'll note here that this was a pattern of the defendant being a drug dealer of multiple substances here. One moment. But I need to consider OB 12 here, am I right? Mr. Saladay, did you score? Yeah, it looks like you scored offense variable 12, and that would be for the delivery of meth. But that's one contemporaneous activity. Am I correct? Is that for the meth?
I scored 10 points for 2 contemporaneous felonious acts.
Oh, you've only got 5. You've got offense variable 12. You scored 5 for 1. So should there have been 2 contemporaneous acts? Because did you deliver? I'm sorry. Yeah, Mr. Dobie.
OB 12, they need to be within
within 24 hours. Yeah, that's why I'm going back. I remember they were close, but they weren't within. All right, thank you. So we had one on October 23rd, and when was the other one? October 23rd is the date in which he got caught with the cocaine, and there was a previous date.
It was October 15th.
15th, yes. Therefore, because the court cannot score that underneath offense variable 12, I'm not using something that's used to score. Therefore, I find that the guidelines are inadequate. The court sentenced the defendant in that file to a prison term of 36 to 240 months with 199 days. I find that there again are substantial compelling reasons, and I also find that today's sentence is reasonable and proportionate. based upon everything I've discussed today, his inability to comply with bond, his inability to comply with parole, his inability to comply with probation, his thwarting of opportunities such as HYTA, the fact that this case involved multiple deliveries, and of course, only one could be used to be scored under offense variable 12. Therefore, I used the other to further my position for my sentence, which does exceed the guidelines. Have I missed anything, Mr. Saladay?
Maybe just language that they're gonna run concurrent.
And that they obviously run concurrent with one another. Thank you, sir. All right, Mr. Doby, have I missed anything on behalf of the people?
No, Your Honor, thank you.
And again, I'm very cognizant of the age of the defendant, but I'm also very cognizant of the fact that he's a repetitive offender, and I think he's probably much older than his number of years because he's experienced a great deal. All right, Mr. Castaneda, Mr. Burdett's going to bring to you. Yes, sir.
Yes, if I could just briefly, Your Honor, when the court was discussing what the guidelines take into account the other deliveries in this case, and he couldn't score an OV 12. OV 15, he received 5 points for that because that took into account the others.
Mr. Burdett, like I said, I'm trying to make sure I don't violate something, and I appreciate that. Thank you very much. I was taking my time to look at the scoring. Let's take a look here at OV 15 then again for that count. 1 second. Mr. Saladay, let's take, what did you do here for?
Scored 5 points on OV 15.
For
delivery and possession.
Because this offense, the offense involved. Yeah, hold on. Look at that offense variable. You scored 5.
Correct.
All right. And I appreciate Mr. Burdett's argument. I don't believe that considered the offenses on the 15th the other day. Therefore, the sentence stands. All right, Mr. Hodgson, Mr. Castaneda, Mr. Burdett's bringing to you 2 copies of 1 document. You're going to place your initials on the first copy for each of the files. Place your initials, neither elects nor waives any rights. It merely acknowledges receipt of your copy of the document. This document, because of the plea, any appeal must be done by filing an application for leave to appeal and not a claim to appeal by right. The claim to appeal by right is only permitted when you're convicted at a trial. However, based upon the original pleas in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, this court finds that not only for addressing deterrence for the defendant, not only addressing rehabilitation, not recognizing that programs are available for them in the prison, but also definitely to send a message of deterrence, because this is becoming a repetitive issue of young men being sent up here by some unknown entity or group of people or person to deliver drugs. Therefore, this court needs to send the message it's doing. Thank you. Mr. Burdett?
Yes, Your Honor. Just initially here. Yes, Your Honor, I presented the notice of timely right to appeal on both files to my client who's currently initialing them, and I'm providing him with his copies of same.
All right, thank you very much. Mr. Castaneda, I want you to take advantage of this. This isn't like you were delivering a gram or 2. Thank you. We're adjourned. Yeah.
Yeah. My client inquired as to whether he would be available for the camp, if the court would consider that.
No.
Reflection on presenting the original signed rights to.
Thank you. I'm sorry, hold on. I actually should say this. I won't make a decision on that until I see it, because it sometimes depends on whether or not they find that he's eligible, find out. So I will say this. I encourage them to apply. I generally do not authorize it from the date one, but I will reduce time. And so I'll normally say I don't object after. So I would probably say after he serves, I don't know what I would do, but often it's 2/3 or half. Serve half, then I'll reduce it by that and give them the opportunity. So the answer is he should apply. I'm just not making a commitment today. I want to see how he does.
Okay.
Thank you.
Thank you.
Your Honor, if I may, he's
Yeah.
not eligible at 36 month minimum.
Oh, what is he eligible at
It
then?
has to be less than 36 months.
All right, well, hold on. Golly gee, let's go. We're still on the record. Madam Clerk, you're gonna do a typo change. I'm just going to amend the sentence for file 13981. We're gonna make it 34 months. 240. Thank you. All those rights I told you about appeal, I remind you about. Thank you. We're adjourned. All right, let's get the next case. People of the state of Michigan versus Scott McDaniel Jr. File 25-14019 of FH. All right, let's get the next case. People of the state of Michigan versus Scott McDaniel Jr. File 25-14019 of FH. I just said Niner. I'm sorry. Okay. All right. Appearances, please.
Jake Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. McDaniel. This is a final pre-trial, Your Honor.
Right. Mr. McDaniel joins us today via Zoom from the Michigan Department of Corrections facility. Mr. McDaniel, are you able to see and hear the court?
Yes, Your Honor, I am.
Thank you. Sorry, final pretrial conference. We are currently set for a trial date. What are we doing?
At this juncture, though, we have not engaged in further discussion today. We don't have a resolution of the case. I would seek to confirm that with Mr. McDaniel, but I believe that to be the case.
Mr. McDaniel, this court has a policy. It is that today on a final pretrial conference date is the last date on which the court can enter a pretrial agreement. Otherwise, we will proceed to trial, or the defendant can plead guilty as charged on that date. This is not at all designed or intended to order or compel anyone to plead guilty or to cut a deal. I make no opinion or statement about my opinion of the case because I have none. I know what the charges are, but I know nothing other than what I see on a single piece of paper called the felony information. Now, the reason that I have this policy, again, actually has nothing to do really with the defendant. It's to compel the two attorneys or the two parties together to have exhausted all their negotiating skills, because I can only do so many trials in a given year, and I cover 2 counties. Therefore, to cause the defendants or the attorneys to exhaust their skills, I do that so they don't try to come to me on the Friday before or the Monday or the day before and say, hey, judge, we want to enter a plea pursuant to a pretrial agreement that, by the way, we could have done 10 days ago, but we just decided not to do our job very well. I'm kind of exaggerating and being trying to be a little bit facetious, but it's to compel them to do their jobs because I do not want to lose that trial date. All right, so that's just my way of saying, Mr. McDaniel, do you wish to enter a plea today, accept the pretrial agreement? Or do you wish to have it set for trial?
I would like a moment with my attorney if I could, please.
Okay, we'll let Mr. Harrison take a brief recess. We'll send him in somewhere else in the building. We're not going to kick you out of the building. And he'll reach out and dial into Zoom, and Madam Clerk will place the two of you into a breakout room. Thank you. We are in recess on that file. All right, we are next taking up the case of People of the State of Michigan versus Jeff. Yeah, let's get Mr. McDaniel.
Yeah.
Let's do it.
Did you see that name?
Okay, yeah,
We are back on the record for People versus Alan McDaniel. Again, file 2514019 FH. The council again are present, and we are now waiting for Mr. McDaniel, who is currently confined in a Department of Corrections facility, to rejoin us via Zoom.
30 seconds.
It is.
Do we anticipate a resolution, council?
We do indeed.
Thank you.
12th, right?
Correct.
Gilby's here.
Mr. McDaniel has now rejoined us. Sir, are you able to see and hear us?
Yes, Your Honor.
Mr. McDaniel, while we were waiting for you to rejoin us, council informed me that there was a resolution. I don't know what that is yet.
I may approach, Your Honor.
You may. All right. I have now been handled a written plea agreement. All right.
Just for clarity, Your Honor, there was a proposed counter offer that I made that was not accepted by, with regard to sentencing, and I'll cover that. Prosecution did not accept.
All right, go ahead and tell me the plea agreement then.
Your Honor, it's my understanding that Mr. McDaniel will plead guilty to count one as charged with a habitual offender second notice, and the people will dismiss the habitual offender fourth notice.
Mr.
My understanding as well.
All right, Mr. McDaniel. Is that what you understand you're doing today?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Now, Mr. McDaniel, back on October 9th of 2024, I believe you were on parole at the time?
Yes, I was on parole and on GPS tether.
All right, and so has the parole board taken, or the Department of Corrections taken an action against you for any probation violation regarding this allegation?
I'm under the understanding I've served my probation time for it, or the parole violation for it. I'm just waiting for the criminal aspect to be done with.
All right, thank you. All right, Mr. McDaniel, you are currently charged on count one with tampering with an electronic monitoring device, such as the GPS device that you mentioned a moment ago. That is a felony punishable by up to 2 years and or up to $4,000. There is a sentencing enhancement listed on the information that's called a fourth habitual felony enhancement. Now that could, within the discretion of the court, increase the sentence from up to 2 years to up to 15 years. However, if you plead guilty to count one, I'm told that you will also plead guilty as a second habitual offender. And in that instance, it could increase the maximum punishment from up to 2 years to up to 3 years. And the fourth enhancement will be dismissed. Is that what you understood you were doing today, sir?
Yes, Your Honor.
Now, by pleading guilty, you will not have a trial of any kind. By pleading guilty, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have to defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify at the trial. Mr. McDaniel, do you understand those rights?
Yes, I do, Your Honor.
And even more importantly, do you understand that by pleading guilty, if I accept that plea, you will be waiving those rights?
Yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal instead of a claim of appeal by right, which is only entitled when you are convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be waiving the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Besides the terms of the agreement that we went over a minute ago, Mr. McDaniel, have there been any other promises, threats, force, or inducements to get you to plead guilty that we have not yet discussed?
No, Your Honor.
Are you entering this plea of your own free will?
Yes, Your Honor.
I must highlight that any sentence that's given would have to run consecutive to whatever sentence you were serving on parole. Now, if you've served all that sentence, then there really wouldn't be any consecutive sentencing. But if you had not yet served it or had not yet been violated on your parole, it would run by law consecutive, which means you'd have to serve one sentence before you were to serve this one. Do you understand?
I do.
Now, I would anticipate Mr. Harrison has gone over the Michigan sentencing guidelines, which are not mandatory. He's probably tried to give you his experience and give you an idea as to what the estimated guidelines would be and as what he thinks this court would do for sentencing. I just want to highlight for you that that would merely be an estimate. Has anyone promised you exactly what the sentence would be from this court, sir?
No, Your Honor, I've got no idea what it's gonna be.
All right. Do you therefore still wish to enter the plea of guilty as we discussed a little while ago?
Yes, Your Honor.
As to count one, tampering with an electronic monitoring device, how do you plead?
I'm guilty, Your Honor.
Turning your attention back to October 9th of 2024 in Cherry Grove Township here in Wexford County. Were you on an electronic monitoring device?
Yes, I was.
And was that for parole, probation, bond? Tell me about that.
I was out on parole, but you had let me go to rehab, and I went to rehab, and I think part of the stipulation was to be on the GPS tether for the remainder of my parole, maybe. I'm not sure if it was the parole or I'm not sure. I just remember being on it, really. I don't know.
Okay. Was he pending a charge and I must have let him on some bond?
We got him, you allowed him to be released to treatment.
Right.
As opposed to reporting back to jail, you ordered him to have a GPS tether.
Thank you. And how did you remove that GPS tether, Mr. McDaniel?
I just cut it off.
All right. And did you cut it off out in Cherry Grove Township? Or was that where you were living when you cut it off?
No, I was driving around and I cut it off and went on the run, or absconded, if you will.
All right. And what did you do with it after you cut it off? Did you throw it out of a car? Or
yeah, I threw it out of my vehicle.
All right. And is it true that also, as for the second habitual enhancement, that back on or about February 25th of 2014, that you were convicted of the felony offense of assault, resist, or obstruct a police officer here in this court in Wexford County?
Sorry, what was that on your honor?
That's okay. To establish the second habitual felony offender, I need to know if you admit that on or about February 25th in 2014, were you convicted of assault, resist, or obstruct a police officer here in the 28th Circuit Court in Wexford County? Is that true?
I was. Yeah, I
All
believe
right.
so, yes, Your Honor.
Thank you. Mr. Carnes, you believe he's provided a factual basis?
Yes, Your Honor.
Mr. Harrison, do you agree?
I do.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
How about you, Mr. Harrison?
Nor am I.
And Mr. Carnes, do you believe that this court has complied with Mission Control 6.302?
Yes, Your Honor.
How about you, sir?
You have.
The court agrees and finds that the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony of the defendant made today on the record satisfies the elements for the offense. Therefore, the defendant is found guilty of count 1 and will potentially be sentenced as a second habitual felony offender. The 4th enhancement will be dismissed at the time of sentencing. Sentencing will be set out in about 4 to 5 weeks. As everyone generally knows, we do them on Monday mornings here in this courtroom. Mr. McDaniel will have to have an updated pre-sentence investigation report done based upon your last prior conviction. This should be very simple and easy. You'll still receive a packet of information. You'll have to complete it, turn it back in. You'll still be subject to an interview with an agent from that office. Make sure that you complete all the information true and accurate. And this will remove the case from the trial. Anything else today, Mr. Carnes?
No, Your Honor.
And Mr. Harrison?
I am satisfied with the record, Your Honor. Thank you.
Now, I'm a little questionable about what to do with the defendant. I'm going to revoke bond and remand him into custody. The reason for that is if he has served his parole violation, then I could see the Department of Corrections wanting space and releasing him. If that happens, I want him to be released to the jail. So he earns credit, obviously based upon the nature of this offense.
I'm currently serving 2 years. I'm not gonna be out before that,
Oh.
sir.
He's not gonna be out for a while.
Okay, well then, still, then it's really semantics. I misunderstood, Mr. McDaniel. I did not realize you were still serving another sentence. All right, well then, regardless, it's merely academic. We'll revoke bond. All right, thank you very much. We should be back here in a few weeks for sentencing. We
Thank
are
you, Your Honor.
adjourned. Thank you, folks.
Thank you, Your
All
Honor.
right, thank you, sir. All right. All right, we are next taking up the case of People of the State of Michigan versus Jeffrey Edwin Stark. This is case number 25-14052FH. The defendant is currently in custody and is being brought to the defense table. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Thank you, Your Honor. Patrick Cherry on behalf of Jeffrey Stark, who's present.
Thank you. You all may be seated. We're here today for some motion entitled Motion for Contempt of Court filed by Mr. Carnes. I haven't seen one like this, or never seen one like this in this kind of case. Let's go ahead and tell me, maybe it's been resolved. Sir?
Yes, Your Honor. So I am asking the court to find Mr. Stark in contempt of court based on my motion. I should apologize. Paragraph 6 of my motion has a typo, or I forgot to finish a sentence. It should finish at the end of Wexford County Sheriff's Office blocked victim's phone.
All right, so let's take a quick look here.
In Your Honor. So if I may,
Yep.
it's my understanding Mr. Stark is willing to admit to every paragraph except for paragraph 8, and the people would be fine with resolving under those circumstances.
All right, so number 8, let's just say, let's clarify, allegedly within a 4-day period of time, the defendant asked another inmate to contact a person whom he has a no contact order.
Yes, Your Honor.
Okay, and that's a no contact order as a part of bond, but not a PPO.
Correct, Your Honor.
All right, got it. Yes, Mr. Trey.
So I guess to make it more specific, you had meant paragraphs 5 and 7. 6, we didn't know what it was until this morning, and I have no way to admit something that somebody else knows. But it's 5 and 7 that he would admit to, that on April 8th,
Yes.
he had contact with Sandra via telephone. And on April 14th, he sent a email through the Signet system.
All right.
And the applicable no contact orders from the pretrial statement signed on April 1st down in district court.
And the remaining posture of this case,
He's scheduled for sentencing next week.
Yeah.
And I'd ask for any sentence that the court's gonna consider on this motion to consider it at the time of sentencing on both files. I will say it this way, the sentencing on these two files is going to take us a minute just because of when he sat, when he didn't set, bond violation that I don't believe he's been sentenced on yet, and then this. So it would probably make sense for the court to consider that all at the same time.
all right. What did he plead to?
Attempted felonious assault in this matter, Your Honor. He's on probation.
Yep.
No, he hasn't been sentenced in the other five.
Oh, my
No.
apologies.
So he's got a probation violation.
He has an OWI, a use of cocaine, and a probation violation in
Okay.
one file.
All right.
And then he has attempted felonious assault and this motion for contempt in this file.
Okay. All right.
Can I clarify that? It's a bond violation, not a
Sorry,
probation violation.
yes.
Thank
Thank
you.
you.
All right. Mr. Stark. Please raise your right hand. Do you swear or affirm that do you swear or affirm the information testimony you're about to provide shall be the truth, the whole truth, nothing but the truth? All right, I'll say it louder. Sir, do you swear or affirm that the information and testimony that you're about to provide to this court will be the truth, the whole truth, and nothing but the truth, sir?
Yeah.
Thank you. Mr. Stark, we're here today for a motion to find you in contempt. Let me explain that to you. When someone violates a term or condition of bond, their bond could be revoked, modified, or continued, and we would address that through a bond hearing. However, your bond, if I recall, had already been revoked for other violations.
Not in
No,
this file.
not in this file, but another file. Regardless, your bond is in effect revoked. So instead, to enforce the terms or conditions placed on you, the prosecution has asked the court to find you in contempt. Now, contempt means that you fail to follow a court order. And it is a criminal offense. However, it is done through a summary proceeding, in which you do not have the right to a trial by jury, but you do have the right to have a hearing in front of this court. If you plead guilty to violating the court order, I can sentence you up to 90 days and $7,000 in fines and costs. And if you plead guilty, you will be waiving your right to have that hearing, waiving the right to have the prosecutor prove the allegation by preponderance of the evidence, waiving the right to have to be presumed innocent until proven guilty, the right to confront witnesses, the right to have the witnesses against you appear at the trial, the right to have the court order any witnesses on your behalf to appear at the trial, the right to remain silent, the right to not have a silence used against you, and the right to testify at the hearing if or trial if you chose to do so. Do you understand? I need a verbal answer. Okay. All right, we will set it for a hearing. Do we have, I'm sorry, I assume the person isn't here today. You don't have any witness?
Trooper Gildy was subpoenaed. I am in contact with him on the phone. If I can call him real quick. I saw a cruiser parked in the parking lot. So
Well, it is a courthouse.
yeah, that's true.
I received an email that your witness is here.
He is here.
We're going to take a brief recess. I'm going to push this here a little bit down the road. We'll recess and have Mr. Stark walk back out. All right. Thank you. Yeah, let's get Mr. McDaniel.
Yeah.
Let's do it.
Did you see that name?
I've done that job. So we're now going to look here at the people of the state of Michigan again. I'm sorry. Again, the case of people of the state of Michigan versus Jeffrey Stark. Counsel, come on down and approach. Mr. Stark. Again, case number 25-14052FH. The court recognizes counsel are again present, as well as the defendant who's being escorted here back into the courtroom. We are here today for a request to hold the defendant in contempt of court. One moment. All right, so we are proceeding here pursuant to MCL 600.1701 and 600.1711. Because this is an allegation that involved misconduct occurring outside of the immediate presence of the court. Conducted hearing. One moment. All right, so we've already discussed and advised the court, through the prosecution's motion and through the statements provided earlier by counsel. The court finds the defendant has now been placed upon a notice of the alleged misconduct. Again, the alleged misconduct involved allegedly the defendant having contact with a particular person named Sandra Valentine in violation of the bond conditions. Either that conduct occurred directly and or indirectly. Mr. Carnes.
Thank you, Your Honor. The people are ready to proceed with the hearing.
And by the way, I'm sorry, I always forget the exact number of the fine. I say 7,000. It's $7,500 and it's up to 93 days. Thank you.
Yes, Your Honor.
All right, sir.
Well,
Wait, hold on.
If I may, Your Honor, court can take judicial notice of the fact that defendant was arraigned on or around April 1st of 2025 with a condition of no contact with Sandra Valentine. And that condition of bond continued after he was bound to the circuit court.
Specifically, the court takes notice of the bond that is contained here, or the pretrial release order that is contained in this court's file. It was signed by the Honorable Judge Corey Wiggins on or about April 1st, and it does have a no contact provision. And then that was adopted by this court when the court issued its scheduling order. That was issued by this court a week later on April 8th of 2025. Thank you.
The people called Trooper Nathan Gildy.
Trooper, if you could please come forward. Your goal is just chair. 42. Trooper, before you take a seat, I'll swear you in. Raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
Trooper, you may have a seat. Mr. Carnes, you may begin.
Thank you. Trooper, can you please state and spell your name for the record?
Nathan Gildy, NATHANGILD.
And are you familiar with Sandra Valentine?
I am.
And do you recall, is it true you investigated an assaultive case where she was the victim and Mr. Jeffrey Stark was the defendant? Thank you. And do you recall her contacting you around April 22nd of this year?
I do.
And at that time, what did she report to you regarding the defendant?
Objection here, say this is a criminal contempt proceeding, therefore the rules of evidence apply.
All right, hold on. I'm going to withhold that because I can foresee where the testimony might change. I'm sorry, not change, where it might go. I will make a ruling on it, and I was expecting that objection. But I want to see what the next set of questions are because, well, I won't say because, but I'll rule on it. And go ahead, Mr. Carnes.
Okay, I will just rephrase the question.
Go ahead.
As a result of your conversation with Ms. Valentine that day, what follow-up did you conduct?
That's what I thought might be the next question, which means, at least for this purpose, the court overrules the objection because it's not offered for the truth. It's offered to state what he did next. Therefore, underneath Michigan Rule of Evidence 801, it is not defined as hearsay. You may keep going.
So on April 1st, I contacted Miss Valentine by phone to get further documentation of her injuries. She had advised that no contact order had been in place. Start.
And then later on in April, she contacted you again. Did you conduct any kind of investigation in late April regarding that no contact?
Yes. From the 21st, she contacted me by email saying that Mr. Stark had
Objection,
contacted.
I'll sustain the objection for the purposes of it. It's offered for the truth of the matter asserted. Yes.
Thank you, Your Honor.
Yep. You can keep going. I will just ignore but I'm looking for the answer to your other question. Just keep going.
Yeah, so after she contacted you, what, if any, investigation did you?
A contact with Ms. Valentine. I was able to review some of the jail phone calls and correspondence through the SIDNet program. And it was noted that Mr. Stark had contacted Ms. Valentine by phone on April 1st and April 8th, as well as an email or an instant message, I believe on the 14th. He had been blocked by administration from contacting Ms. Valentine.
Were you able, focusing on the conversation on April 8th, were you able to listen to that conversation?
I was.
And what, do you recall anything that the defendant said, or do you even, let me just say, moving back to March 31st, had you contacted both of these individuals, both Mr. Stark and Ms. Valentine?
Yes.
Were you familiar with their voices?
Yes.
When you listened to the phone call, whose voices did you hear?
I heard Mr. Stark and Ms. Valentine.
Thank you. I am now approaching the witness with what has been marked as People's Proposed Exhibit 1. Do you recognize that document?
Yes.
Can you tell me what it is?
This is Ms. Valentine's contact ID or profile in SIDNet.
Is that a true and accurate copy of what you saw in SIDNet when reviewing Mr. Stark's SIDNet file? Your Honor, at this time, I would move to admit People's Proposed Exhibit 1.
Your Honor, if I could have the exhibit for a moment.
Of course, you may approach. Permission to move about the courtroom to counsel is granted. You don't need to ask again, just help yourselves. Unless the trooper is worried about being attacked. All right, he's fine.
That's mine. And they're saying I messaged her about the cat.
Right now, I'm just asking, is that her email address?
I believe so.
Okay. No objection, Your Honor.
All right, the proposed exhibit is hereby admitted. Mr. Carnes, you may again hand it back to the trooper, and you may continue your questioning, sir.
Your Honor, actually, at this time, I would ask to publish this to the court.
Okay. Thanks. All right. Thank you. You may continue.
Thank you. Your Honor, at this time, I'm approaching the witness with what has been marked as People's Proposed Exhibit 2. I'm giving Mr. Cherry just a minute.
Sure.
Wanted to watch the cat. That was the big. I don't know. I guess you need to- I don't know.
Trooper Gildy, do you recognize this document?
Yes.
And what is that?
That is a instant message or an email sent from Mr. Stark's Sidnet account to Miss Valentine.
And is that a true and accurate copy of something you reviewed when reviewing Mr. Stark's Sidnet account?
Yes.
Your Honor, at this time, I would move to admit People's Proposed Exhibit 2.
No objection. People's 2 is hereby admitted. You go ahead and hand it to me. Thank you. The trooper is compliant. Thank you. You may continue, Mr. Carn.
Thank you, Your Honor. I am done presenting evidence, and just for completion, I would ask the court to strike my paragraph 8 from the motion. I'm comfortable with the proof that they exist.
Okay, I will ignore paragraph 8. Thank you.
Thank you. No further questions on behalf of the people.
Mr. Cherry.
On the Sidnet account, is there a monitoring system to know who sent that message through Mr. Stark's account? Is there some fail-safe to make sure that somebody else isn't using Mr. Stark's account?
I'm not familiar with the process of the workings of this Sidnet.
Are you aware of any issues in the jail with people using each other's Sidnet accounts to reach out and contact other people?
I've heard of that happening.
Okay. So you don't have a video capture or something to say that Mr. Stark was the one sitting at the computer sending that message?
I do not.
Okay. Is there a photo that's captured when somebody sends a message?
Not to my knowledge. I'm not sure.
Okay. So we just know that that was sent from his account, but we don't know that he sent it.
Correct.
And then I just want to make sure, I understand the April 8th phone call. To your knowledge, was Mr. Stark incarcerated on April 1st? You had mentioned an April 1st phone call.
You mentioned the April 1st was just the initial report to the initial allegation, and then Mr. Carnes jumped forward.
Okay, I just wanted to make
No,
sure
no.
I wasn't conflating.
I'll just say that's what I understood.
All right. Nothing further, Your Honor.
And again, Ms. Trooper, you recognize the voice, Mr. Stark speaking to the other person, which voice you recognized to me, Miss Valentine's.
Yes, sir.
And what was it that Mr. Stark said during that conversation that you overheard?
It was about a 20-minute phone call. Mr. Stark called Miss Valentine. He said, "Hey, baby," and she said, "Hey." They discussed. He had been reprimanded and placed back in jail. They were both kind of outraged about that. She had been trying to contact Facebook, and it sounded like they had re-sparked their relationship at that point, and they discussed, kind of, so to speak, their life moving forward and him working through his legal issues.
Any further questions based upon mine, Mr. Carnes?
No, Your Honor.
Mr. Cherry?
No, Your Honor.
Trooper, you may step down. You're free to go about your day. Thank you for your time.
Thank you, Your Honor.
Mr. Carnes, anything further to add?
No, Your Honor.
Mr. Cherry?
No, Your Honor. Just argument.
All right, argument, sir.
Thank you, Your Honor. I would ask the court to find defendant in contempt of court. I am asking for the full 93 days allowed by statute MCL 600.1701 subsection G. I have no objection, however, to the court setting sentencing on this out, as I anticipate Mr. Cherry will request for sentencing on the underlying file, which I believe is next week. Thank you.
Thank you, Mr. Chair.
Thank you, Your Honor. The burden of proof in a criminal contempt proceeding is beyond a reasonable doubt. I think that in terms of the April 8th phone call, the trooper was clear. However, in regards to the SIDNET message or the other allegations made in the complaint, there's not evidence beyond a reasonable doubt. Mr. Carnes is correct. If the court does find Mr. Stark guilty of criminal contempt, I would ask that sentencing be scheduled for Monday, May 19th at 9:45 a.m.
Thank you. All right, this court finds that beyond a reasonable doubt, based upon the pretrial release orders based from the district court and the schedule order issued by this court, in addition to the officer acknowledging that, yes, I've heard this person and I recognize the voice, and the fact that we continue to talk about the defendant's criminal case, and that there was some kind of reigniting of the relationship or rectifying to some degree between the two. Therefore, I don't think that was somebody else from the jail, building a relationship with her. And I think that further lends support and credibility that the other message that was sent via the form of email, it appears to be the same thing. It talks about her staying in the house, taking care of the cat, and whether that was direct or even indirect. I find that there's probable cause to believe the defendant violated the no contact terms or conditions. Therefore, the court finds the defendant guilty of violating and found guilty of criminal contempt. Now, I understand both parties have asked me. I'm going to walk you through this. Number one, I could always take it into consideration, the finding of preponderance of the evidence, by the way, at a sentencing hearing. But the contempt court is perfectly fine. Now, here's another thing. If this were to be asserted just during the sentencing, I'd include it in the sentence. So, the court is going to proceed to sentencing now, otherwise it would not have any impact. Okay. So, as the sentencing, sir.
Thank you, Your Honor. This is a situation of a felonious assault in a domestic relationship. That's what the defendant's on bond for. The court had very good reasons to place a no contact order. Placed defendant violated that no contact order when he called Ms. Valentine on April 8th. The jail away his ability to contact her by their voice app on April 10th, and then the defendant sent the victim a message through the system, which he was somehow able to get through. This is repeated violations of a court order. I do think the maximum sentence of 93 days is appropriate. I'd ask that. And I'm sorry, I misspoke earlier. The penalty statute is MCL 600.1715.
Thank you. All right, Mr. Chair.
Thank you, Your Honor. The underlying case was charged on April 1st of 2025. The 7 days in between the felonious assault charge and the time when Mr. Stark made the phone call and ultimately his bond was revoked, the court may recall, we came up on a bond violation arraignment in his other file on the 8th, and that's when the court revoked his bond in both files. So that was the day of arrest on the bond revocation.
And what date again?
April 8th. The day of the phone call.
Yep, thank you.
So I want to He's out for 7 days after this incident takes place. They have clearly rekindled, whatever incident had began on April 1st. And on April 8th, he was calling to let her know because he was here. And immediately, because we didn't know he was going to be arrested on the violation when he came to the courthouse, he called to let her know that he had been arrested per the trooper's testimony. And then the follow-up email was to let her know she could stay at the house. They have a cat together, wanted to make sure that the cat was being taken care of. That doesn't negate the fact that there was a pretrial order. What I'm pointing that out for is the egregiousness, or I guess this isn't, he's not calling to threaten her for pursuing the charges. He's not calling to try her and talking her out of things. This is, hey, I've been arrested, and hey, can you stay at the house to take care of the cat? And so I point that out when we're talking about the degree of what she should be sentenced to. 93 days is the maximum allowable sentence, and it's a consecutive sentence. This is a big hammer. If it were a bond violation hearing, likely it would result in a revocation of bond, because that is usually what happens, and it would be taken into consideration at sentencing. So I'm asking the court, if any sentence of incarceration is issued, that it be a short sentence to send the message, hey, you've got to follow my orders, but also recognizing this isn't the most egregious breach of a no contract order that I'm sure this court has seen.
Mr. Stark, is there any you wish to say? You have the right to. Yes, sir. You may remain seated.
Whatever you want to do here, what do you want me to?
I want to know, is there anything you wish to say? It's up to you.
I haven't been in my old jail cell for 3 weeks. I've been in a different J-pod where I am now. I haven't been involved with that Hiddle guy for quite a while. I don't know.
Those have been dropped.
Okay.
Yeah, those were dropped.
I just appreciate whatever happens next 19.
All right.
Move on. Sorry.
Okay. Well, first, this is a case involving domestic violence, and there's been a conviction. Domestic violence, we know, involves power and control. And even when somebody who is involved in committing domestic violence reaches out and tries to say, hey, baby, I love you, everything's okay. Well, that's just part of the cycle. That's why it's a wheel. It just keeps happening. Could keep happening. That's why courts give no contact orders. And when the court sets a no contact order and a defendant chooses on his or her own to basically tell the judge, Judge, I don't care what you say or do, I'm just going to do what I want. Yeah, that's offensive. That's why it's called contempt. I don't care what your reasoning was, what your thinking was, anything. No. I tell you, don't do it, you don't do it. Very simple. And you don't get to second guess, because I'm going to tell you, when it comes to sentencing, I don't know what your prior criminal history is. If you have any, I don't know. But I look and see, does this person follow orders? I even look at things that people say are ridiculous offenses, like driving without insurance or driving while your license is suspended. Well, that is kind of a minor offense. That tells me that a person will say, I don't care what the state of Michigan, who owns the roads and gives me the authority to drive a vehicle on them, and that it's their choice. I'm going to do what I want. That's what those things tell me. So, I'm not going to hit you with 93 days, but I am just going to give you a little bit of a sting, because you won't get credit for this on your sentence that you get soon. The court sentences the defendant to 10 days. Not a lot, but it's enough to identify that this is an order from the court and you follow it. By the way, that's generally what I give for contempt. Like when I get people from the jail who appear on the screen, they decide to start explaining what I should do with myself in a dark room. I generally give them 10 days, maybe 30 at most. but it's just enough to send a bit of a message. The court says, don't contact her. I don't care if she wants to talk to you. And by the way, cats are quite resilient. Find a way to live, so they catch mice. Anyways, that's the sentence of the court. You have the right, oh, no, that's just a missing. All right, anything further?
Every day in the USA, people find themselves in court.
You're welcome. Thank you, Mr. Case.
Yep.
All right, being in recess on Davis, let's take up Hinojosa on the record in 2024 CR 501, State of Kansas versus Joseph M. Hinojosa. Please announce appearances.
Jerry Gear on behalf of the state.
Good morning, Judge. Mr. Hinojosa appears via Zoom along with counsel Kelly Reynolds.
And how does he wish to proceed today, Mr. Reynolds?
Judge, we would request one more status setting. If the court is not inclined to do that, we're prepared to set dates on this for a trial.
Well, you told me April 7th that you needed another continuance, and I granted it on the condition that this would be the final time. Why are we needing more time?
Just to try to work out a resolution, Judge, but we're prepared to set it for a trial.
All right, let's set it for trial. Do you want bench or jury?
It would be a jury trial, please, Judge.
This is continued at the defendant's request to, my next one is October after, I've got one this coming week, but that's too soon to get it on there. So October, what's our next date, Jen? For jury?
Pre-trial is September 29th. Jury trial is October 1st and 2nd.
All right. That will be the order of the court. The matter is continued for jury trial. Demand will need to be made for jury trial in writing, of course. And pre-trial, the defendant must return September 29th at 9:30, September 29th, 2025 at 9 o'clock. I'm sorry, at 9 o'clock. That will be by Zoom, but the jury trial will be live in person October 1st and 2nd. If, Mr. Reynolds, you reach some kind of agreement before then, please consider putting that on an expedited control docket.
Understood, Judge.
All right. Anything further from either party? Defendant continued on bond.
Nothing from the defense.
No, Your Honor.
Okay, and where is the defendant?
His screen does say Josephine.
Right here, right here.
Very good. All right. Thank you, sir. You must be back here at those dates and times. Your bond continues.
Thank you for the court's time.
You're welcome. We'll be in recess. The defendant and counsel are excused at this time. We will now take up case we are on the record in 2021 CR 497, State of Kansas versus Zachary Enoch Compass Whittle. Please announce appearances.
Jerry Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Zachary Compass Whittle, who does appear from the Butler County Detention Facility. Judge, this is a case that's previously set for jury trial. Mr. Whittle did not appear and a warrant was issued. He's in jail at this time. We're asking that it again be set for jury trial.
Well, I'm inclined to think he needs to stay in custody until that jury trial because
Judge, he
Yes.
is currently on a DOC sentence that will take it past whatever date I think the court would set for jury trial. So yes, I don't believe he's getting out of custody.
And Your Honor, what I would tell the court is this is a case where this case has been set for pretrial and jury trial on two separate occasions, September 30th and February 3rd of 2024 and 2025 respectfully. My notes indicate the defendant failed to appear at both of those settings.
Well, and that's why I'm thinking he needs to stay in custody until his jury trial, because I can't trust him not to be it here. In the meantime, we'll set this over. The next one starts next week, but that's probably too soon. So pre-trial will be September 29th by Zoom, 8 a.m. Jury trial will be live in person October 1st and 2nd. Defendant must be here in person, ready to go at 9 a.m. But in the meantime, I'm going to order that. Is there any objection to just a flat no bond hold, Mr. Patterson, or do you want me to put a dollar amount on it?
Judge, that's fine.
Okay. Mr. Compass Whittle, are you okay with that?
Yeah.
All right. That will be the order of the court then. And if he goes to, is this a DOC, did you say?
Pardon me, Judge?
Did you say it's a DOC hold or?
He is currently sentenced to the Department of Corrections. That's correct.
All right. Well, we'll need to make sure we get him back here if at all possible for that pre-trial at least.
With the no bond hold, I think he'll probably just end up staying in Butler County, Judge.
Okay. All right. That'll work for me if nobody else has anything they want to be heard on. All right. Thank you.
Thank you, Judge.
All right, you are excused and remanded to the sheriff, Mr. Compass Whittle.
Thank you.
You're
Judge, the last case in custody is Bailey Collier. I would need a breakout room with Mr. Regier on that case.
I will, if you'll take a brief breakout room.
Was his, but he did not talk to Dicus. He said that he did not have Dicus.
All right, can we bring Mr. Dicus in?
Yes, ma'am.
Thank you.
Dicus.
And Your Honor, the state is not aware of any formal entries of appearance or orders appointing counsel in this case.
We are on the record in 2023 TR 3035, State of Kansas versus Isaiah David Dicus Salzman. Jared Regier appears for the state. The defendant, Mr. Dicus Salzman, appears in person in custody of the Butler County Detention Facility in pro se. Mr. Dicus, you had your first appearance scheduled December 27th of 23, but you failed to appear, at which time a bench warrant was ordered.
Yes, ma'am.
You then appeared August 21st of 24, almost a year later, entered a not guilty plea. You did not qualify for court-appointed attorney, and $1,000 cash or surety bond was ordered. You made that bond with hot rod bail bonds, but then you failed to appear on that bond November 4th of 24. Another bench warrant was issued, bond forfeiture, and your new bond was set at $2,000 cash or surety. Then you next appeared March 24th, 2025. The state withdrew the motion for judgment on bond. The jail was to follow up on your warrant. You were going to hire an attorney. So you apparently have, and then you were ordered to appear April 4th and you failed to appear a third time. having bonded right before your hearing date, maybe, let's see, I'm reading that wrong.
And Your Honor, I believe I am in a position to
Okay.
make short work of this if the court wishes.
Go ahead.
Your Honor, in the current case on the docket 23 TR 3035, I am showing that an appearance bond was executed for today's date and time, 2,000 professional surety. This is a defendant who appears to have multiple Butler County cases, a total of 4. The state's understanding is that in 25 CR 184, there's an appearance bond was previously executed for 2,500 professional surety, as well as in 25 CR 186. I'm showing a 5,000 professional surety bond in that case. Both those cases appears to be set before this court on June 30th at 9 a.m. based off my notes. There does, however, appear to be a 4th case, Butler County 25 CR 190. The state's understanding is that matter is currently scheduled for preliminary control hearing on June 16th based off my notes. And I am not showing that an appearance bond has been successfully executed in that case.
All right. And which judge, if you know, is that set for?
Forgive me, Your Honor, I will need a moment to
No, that's all right. That's all right. Don't worry about that. All right, I'm going to continue this one over to June 30th at 9 a.m. And Mr. Dykus Salzman, do you have an attorney in those misdemeanor cases that he mentioned?
I don't think I do, ma'am. I thought I had an attorney named Quentin Baker, but I think I got a different guy. So I don't know, ma'am, if I do or if I don't.
How long have you been in custody?
Since April 7th.
Do you have any income?
At this moment, I haven't been working, so no.
Do you have any money to hire an attorney?
No, ma'am.
Okay. I'm going to appoint Attorney Darren Patterson on the 3 misdemeanor cases, Jim, and that would include this one, 2023 TR 3035. And then Mr. Patterson, those other 2, would you state their numbers again? I mean, Mr. Regier.
Yes, Your Honor, the state's understanding is that 25 CR 184 as well as 25 CR 186 are currently scheduled for before this court on June 30th. It would appear that there was a first appearance hearing conducted in both those cases before Judge Hart on April 18th, at which time the court made a finding that the defendant did not qualify for court-appointed counsel.
And when was that?
April 18th, based off my notes, Your Honor.
All right, well, it sounds like he hasn't worked since then. So I'm going to find he does qualify and appoint him in both those cases, Jen. That's 25 CR 184, 25 CR 186, as well as today's 23 TR 3035. Please get the orders of appointment to Mr. Patterson. CA, please get the discovery to him. Mr. Patterson's office will need the contact information. Mr. Patterson, you've just been appointed in 3 cases set for June 30th. Is that a Monday?
Yes.
Okay. For Monday, June 30th, 9 a.m. And he also has a felony for PHC June 16th. I don't know who represents him in that.
And what is this person's name, Judge?
His name is, he's the one in the jail there at the detention. It's Isaiah, Isiah, David, and then the last name is hyphenated, Dykus, Dicus hyphen Salzman, Sulzman. And do you need those case numbers again?
I'll look it up, Judge. That's fine.
Okay.
Thank
All
you.
right, thank you. And bond has been set in this matter. So at this time, is there anything further we need to address?
Your Honor, if the court is continuing the bond in the case actually on the court's docket today, the state has nothing further.
Any bonds already set or continued, any unmet, will remain at the amounts previously scheduled. You must reappear at that date and time, June 30th. I'm going to order at 8 a.m. on those. Or do you want him at 9 since he's in case he stays in custody, Mr. Patterson?
9 o'clock's fine if he's in custody, Judge.
All right, we're going to leave him at 9 a.m. I don't know if you'll be in custody then, but
Probably
I'll
will.
cover it if you are. Okay. All right, thank you.
Thank
You'll
you,
be in
ma'am.
recess. You may go.
Information, that's your next one.
Okay, thank you.
All right, let's see.
I did it
Mr.
soon.